Royal Commission is now in session. Please be seated.
Shall we get the appearances for the day, Mr Gregory?
Yes, if it pleases the Commission, I appear with Ms Marsh today.
Thank you.
May it please the Commission, I appear with Mr Glover today.
Thank you. Yes, Mr Gregory?
Yes, Ms Campbell has returned to resume her evidence, but before I start with her, can I update the Commission on a procedural matter?
Yes.
Last night there was correspondence between the solicitors assisting the Commission and the solicitors assisting the Commonwealth in respect of the Ombudsman. The update is that the Ombudsman's office is prepared to voluntarily assist the Commission and provide documents to Ms Louise McLeod, who was involved in early 2017, and it is anticipated that Ms McLeod is willing to give a statement and assist the Commission in hearing Block 3.
Thank you.
Ms Campbell, I think, remains under her former...
Yes, you understand that, Ms Campbell. Thank you.
Thank you, yes. Ms Campbell, you were served with a notice to give a statement and produce documents NTG 0057 dated 24 October 2022.
Yes, Council.
And you provided a statement in response dated 25 October 2022.
25 October. That's my understanding. I'm just trying
That's
to...
your recollection, yes. And you were also provided with a notice to give a statement and produce documents NTG 0043 dated 26 October 2022 and produced a statement in response sometime later.
Yes.
Yes, thank you. Commissioner, I tender both notices and statements which appear on the draft list as Exhibits 1744 through to 1747. There are additional documents which will be tendered also, which appear on the draft list from 1748 through to 2029.
All right, those documents will be admitted as exhibits with the numbers they bear in the schedule. Thank you.
Thank you, Commissioner. Ms Campbell, the Commission heard some evidence Monday from Mr McNamara, who came to work in the department in respect of the Ombudsman's inquiry in January 2017.
I think Mr McNamara came to work in a broader range in the compliance area. I don't think it was just for the Ombudsman's report.
Certainly.
Yeah.
He gave some evidence about your personal characteristics as a secretary and some observations he made of you from that point forward. He described you as a detail person, someone who focused on the detail. Would that be a fair observation?
I think during that period I was very focused on the detail with respect to the scheme, yes.
And that involved both media issues and compliance issues generally?
So I think it was at that point in time I was very focused on the online compliance initiative and the media attention that was being received from it, as well as the broad range of the recipient experience and the entire program.
Yes. Yeah. He described that in respect of statements that went to the media or the minister, I think that you were prepared to involve yourself in working over the language and drafting various documents.
I think on some occasions, yes.
Yes, all right. He used the phrase hypercare in terms of the sensitivity of the OCI program in January 2017. Is that a phrase you're familiar with?
No.
Right. And he also described the department as hierarchical. Would you agree that by virtue of the structure of it, it is necessarily hierarchical to some extent?
I think it is, particularly when there were about 35,000 people in the department, yes.
And in respect of the OCI program particularly, there was, because of the sensitivity of it in January 2017 and your involvement at the top of the hierarchy, the need for a lot of information to be conveyed to you through that structure.
I think during that time, both myself and the then Minister were involved with it, yes.
Yes. The then minister, as I recall, was Minister Tudge.
That's correct.
He returned from holidays on about the 8th or 10th of January 2017.
You did.
And I think you returned from holidays at about that time as well.
I did.
You may have come back early.
I did.
From that point in time, whatever day it was, do you recall that you spent a good deal of time with the minister in his office reviewing aspects of the program with him, including the media issues?
I think I spent significant amounts of time. Often the minister was down in the department as well.
Right, okay.
So it wasn't just in his office. He was in the department as well as we worked through the issues and sought to rectify them.
And in terms of your observation of the level of Minister Tudge's attention to the matter, would you say that he was focused on the detail of the media as well at that time?
He was focused on the detail of the program,
Yes.
which included the media.
Right.
But he was also focused on the process, including from the recipient experience.
I'm aware of a speech you gave to an APA conference or APAA conference where you described working on letters with Minister Tudge, which went through a user experience.
Yes, the IPAA,
APAA,
can't remember what that stands for, I'm sorry.
that's all right.
Yes, we worked on some letters, yes.
And where did that happen, in the DHS office or in his office?
I think it was the DHS office.
And these letters were letters that were being sent under the scheme to recipients?
These were letters that we were working on to improve the letters that were being sent to the recipients, yes.
And in that process, did you and he work out or revise the phrasing in the letters, that sort of thing?
I think on one occasion we did, and then that letter was tested with recipients.
It
And
ended up not making its way into the final version, I guess.
no, it didn't.
But it reflected the level of detail that Minister Tudge had in respect of the program generally.
I think it reflected at that point in time, in the first weeks of January, the need to improve the process, and that both the Minister and I had engaged with that process. I think that example I gave during the IPA speech was one that sometimes the intent was that, of that comment, was that sometimes it's best left to others to do that type of work, and to also understand that citizens sometimes come at things from a different way, and using the co-design and testing of such letters was a beneficial process.
Because ordinarily it wouldn't be the case that the minister would settle letters together with the secretary, which are sent out to recipients.
No.
No.
But letters are a very contentious issue in the then Department of Human Services, and even now in Services Australia, letters are something that there is significant debate about.
Yes. You made reference on the previous occasion when you gave evidence to the administrative arrangements orders and the areas of responsibility for the Department of Human Services.
Yes.
If Exhibit 1985, RBD 9999 0001 0045 could be produced. Just having the page number turned up, but Ms Campbell, you'll recognise, I think, the front page of the Administrative Arrangements Order dated 23 December 2014.
Yes, Council.
And as the Commission has seen through other witnesses, including Mr Pratt, this is a comprehensive document which is issued almost always in respect of all government departments and all administration administered by those departments.
That's correct.
If it's convenient, exhibits 1985 through 199 So 1990 could be tendered.
Do you want to do that?
Yes.
Yeah.
And look, just while we're on the subject of exhibits, 1744 actually was an exhibit yesterday already, so the notice to give a statement, which I had earlier said could have that number, will now be 1744A.
If we could just skip through the pages until we reach the Department of Human Services. Thank you. At page 26 appears the orders relevant to the department of which you were the secretary, Ms Campbell.
Yes.
It identifies there that the matters dealt with by the department are the development, delivery and coordination of government services and development of policy on service delivery.
In that version, yes, that was
That's right.
the case, yes.
There were changes to the terms of the administrative arrangements orders over successive orders,
There was.
but I think this was the version as it was, which was current at the time OCI was introduced.
Yes.
It also refers to monitoring and management of service delivery arrangements involving social security. You gave evidence at the last occasion that the department, that is DHS, had responsibility for ensuring the legality of service delivery
Yes.
or lawfulness of service delivery.
I can go to the transcript to just see exactly what I said there.
Might be at page 961.
961.
Yes. About lines 38, I think.
And your question to me was including the lawfulness of the method of implementation, and I answered yes.
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 And that is a reflection of the administrative arrangements orders which designate responsibility for social service delivery to
Yes.
DHS.
And yes.
There may be some other statutory requirements under the Public Service Act or the Public Governance, Performance and Accountability Act, but in any event, your answer derives from the terms of the administrative arrangements orders.
Yes, and I read that with the when looking at lawfulness, how we implemented the program.
Yes. The reference there to the development of policy on service delivery includes, in this case, the policy which surrounds the delivery of the OCI program.
The delivery.
Yes. Yes. And included in the delivery of the OCI program was the basis on which debts were calculated and money was recovered.
Yes, how it was implemented. Yes.
That's right. Yes.
Yeah.
The information that you obtained through Ms. Golightly in the development of the 12 February 2015 executive minute to Minister Morrison, did you understand from that information that there were policy concerns from DSS about the implementation of the proposal as it was then understood?
I understood that DSS had wanted to continue to work in that proposal
Yes.
and that the advice we were giving to the Minister for Social Services was that we would continue to pursue those issues with social services.
And those issues were the question of legislative change and or policy change.
That's right.
Thank you. If
Just ask whether we could turn that light down as well. Just realised there's another light.
If Exhibit 2028 could be placed on the screen. I'm going to take you to the executive minute itself in full form, Ms Campbell. CTH.2004.0002.2505. Commissioner, I understand there was late agreement on the inclusion of the document, which
But it will,
might explain why the document manager is loading the document.
but it is coming.
It is coming. Thank you. Ms Campbell, on the screen is Exhibit 2028, which is the cover email for attachment B15125, Deputy Secretary signed brief. That was the 12 February 2015 executive minute from DHS to Minister Morrison for action.
I don't know whether that's the case or not.
Okay.
I don't think I'm copied in on that brief.
You're not copied in, no.
So I have no way of knowing, I'm sorry, and I haven't been able to see that document in the lead up to today.
Okay. Perhaps if we go then to Exhibit 2029, CTH.2004.0002.2506, the attachment. While that's coming up, Ms Campbell, in terms of your involvement in the preparation of the executive minute, I recall you gave evidence that you were involved in the various drafts of the executive minute to Minister Morrison together with Ms Golightly.
I was involved in a number of drafts. I can't say whether that was every draft, because I would have to have a look at each and every one to make sure that they were the case. So the ones from my review of my emails I have discovered, and the documents that I was involved with some of the drafts, yes.
All right.
And then I would have been copied in on the distribution list at the top of the final one.
That's right. So we can see the reference there in the top right-hand corner to your position.
Mm-hmm.
We can scroll down to page 4. Ms Campbell, you can see there following paragraph 23 the signature of Ms Golightly, although it's been blacked out, and the date 12 February 2015.
Yes.
Now, the final version then of the minute was something, as you say, that was copied to you.
Yes.
And do you recall asking or answering questions that I asked about this executive minute on the previous occasion?
I remember answering questions, yes, Council.
And you might recall that the document about which I questioned you contained Mr Morrison's signature of various highlighting and circling in respect of options to progress matters or discuss matters or not to proceed with matters.
I do recall that, yes.
Yes. Do you recall also that there were 11 pages of the document that I showed you last time with Minister Morrison's signature on it?
I don't recall that, no.
All right. You may take it from me that there was only 11 pages. This copy contains all 17 pages. And if we go back to page 1, ending 2506. Thank you. Ms Campbell, you can see in the box of recommendations, item 3 is a request to note the current arrangements to maintain the integrity of welfare payment outlays, attachment B. And then go to page 12 of 17. You can see in the top right corner, attachment B. And it is a total of 6 pages through to page 17 of 17. I'll take you to some specific portions of it firstly, and you may recall them from previous drafts in any event that were exchanged with Minister Payne. But Commissioner, I can explain that the missing pages in the previous hearing block have been explained now by correspondence, which indicates that the Minister's office, that's Minister Morrison's office, or Minister Morrison retained attachment B and it wasn't returned to the department.
Oh, I see. All right.
And the emails which reflect that position at the time the attachment in part was returned or the minute in part was returned will be tendered.
Thank you.
Yes. The passages to which I want to have your attention drawn, Ms Campbell, commence at page 13 of 17, ending 2518 at paragraph 12. And if paragraph 12 could firstly be called out, and I'm going to ask you to read just to yourself through to paragraph 23, and we'll just deal with the paragraphs sequentially.
I'm ready to move to the next page, thank you.
Thank you, Ms Campbell.
I'm ready to move to the next part, thank you.
Thank you.
I've finished reading up to paragraph 20.
Thank you.
I'm ready to move on, thank you.
Just through to the end of paragraph 23. Thank you, Ms Campbell.
Thank you.
Thank you. Ms Campbell, do you recall working on a draft with Ms Golightly which contained effectively the same information?
I recall, now that I've been able to look at the data and look at the information, I recall working on this, but I recall it at that point in time, yes, but it's not something, the detail of every brief unfortunately don't remain with me until I have my memory refreshed.
Certainly. We could go back to paragraph 14. It identifies a response to a problem which is set out earlier, but it identifies inconsistencies between information customers have given to different areas of government, and paragraph 15 refers to PAYG information. The two letters which recipients received under the OCI program, the first of which has been described on a number of occasions as the identification of a discrepancy. Is that language familiar to you?
Yes.
And here in paragraph 14, the word inconsistency is used, but I gather it's the same concept.
Yes.
The concept of a discrepancy as it was identified in the original letters, that is the initial letter sent to customers under the OCI program, must have resulted from some comparison of information held by DHS and information from the ATO.
Yes.
And the information held by DHS, I take it, would have been reporting during fortnightly periods when persons received an income support supplement.
Yes.
And the information from the ATO, I understand, is the PAYG summaries which are provided by the ATO to DHS.
Yes.
And in order for an inconsistency or a discrepancy to be identified, as you've indicated, there was a comparison between those two data sources. Did it involve the application of an initial concept of averaging in respect of the PAYG summary to the information reported by the recipient to Centrelink?
My understanding, it was over the period that the ATO had reported that those earnings had been achieved. So if it was over a 3-month period, there was an averaging over the 3-month period. If it was a 12-month period, it was an averaging over the 12-month period.
And what is reflected, I think, in attachment A, which I took you to last time, is that the application of that concept of inconsistency was not a new feature of the program, but the concept of the PAYG data being the primary source of information to establish a discrepancy was a new step in the OCI program.
I think I answered last time that in the manual system it had been one element.
Yes.
It had often been in the manual system the reason why a manual compliance had been undertaken. Was
The trigger point.
Yeah, it was the trigger point. Yes.
But here, that is, under this proposal, and I appreciate it's a proposal at this point, the scheme's not implemented, the proposal was that the trigger point would not be a trigger point for a manual investigation within Centrelink, but a trigger point for the initial letter.
Yes.
And that in the event that the customer responded to the initial letter, their information would be taken into account, in part manually, on a review process.
Yes, and I think the intent was that we were encouraging as many people as possible to respond to those.
And in the event that a customer didn't respond, that initial averaging, which triggered the initial letter, was applied to arrive at a debt or not.
After a reminder letter, and I think my statement indicated that I was concerned early on that there hadn't been enough efforts made to contact the customer.
Yes. But ultimately, in terms of what information was provided or not, where information was not provided for whatever reason by a recipient or intended recipient of the letters, the initial data match was effectively crystallised into the final position and reflected a debt.
And that was the initial rollout, and that's why we sought to change that after we were aware of the shortfalls in the initial rollout.
Right. And so would you agree with me then that one change in the proposal, just dealing with it at this stage, was the change from the trigger for an internal review versus the trigger for the initial letter?
Yes.
The problem which was identified in paragraph 14 was set out in more detail in paragraph 12 and paragraph 13, and it identifies there, or it is identified there, that welfare claimants have variable circumstances essentially, and there are complexities to the reporting arrangements and the receipt of benefits.
It is a very complex system, and that was identified here.
Yes. And the reporting of changes in circumstances to real life situations can make it difficult to comply with the rules, even where there is a desire to do so. That's a reflection of the complex system.
That's right.
And it's a key driving factor, according to the proposal, of levels of customer error.
That's as per that paragraph. That's what that paragraph says.
Yes. Now, returning then to paragraph 14, the shortcomings in the PAYG data were identified in the second paragraph, commencing with the sentence, however the range of data, if that could be called out. Or if not, perhaps expanded a little. Thank you. the range of data currently matched against, that's a reference to what you just described as the information reported to Centrelink by the recipient and the PAYG data.
Yes.
And the variability in timeliness and quality, firstly in respect of timeliness, is a reflection of the periods which PAYG data can be reported by employers to the ATO.
That's my understanding of that, yes.
And it can have then an effect on the quality or the ability to use the PAYG data in a more timely and efficient manner.
That's what the paragraph indicates.
That's what the paragraph says. And one of those features is because it is, to your understanding, I suggest, only a requirement on employers to report the PAYG data close to the end of the financial year.
I'm not aware of that.
You're not aware of that. The reference to the limits in respect of legislation and policy, at least legislation we've addressed before, that related to the ability to use PAYG data on an averaged basis as evidence of actual income during a fortnightly period.
Yes, we discussed that last time.
And the policy questions, if I can address those with you now. Would you agree that in respect of the concept of averaging PAYG data and using it as actual evidence of fortnightly income, that there is likely to be a variation between the averaged figure and the actual income figure for any particular fortnight?
There could be, depending on the circumstances of the employment. If the recipient who's reporting was working the same pattern, it's possible that the amounts could have been equal. If they were working irregular hours, it's possible that it wouldn't.
And so in respect of casual workers, there was a risk that the averaged income would not reflect actual income?
That was the case, yes.
And with seasonal workers?
Seasonal workers there were different rules around seasonal workers. I can't recall what they are now, but there are different rules in the Social Security Act about seasonal work.
But for example, if someone worked 6 months of the year in a fruit picking season and then didn't have employment for the following 6 months of the financial year, but an employer reported their PAYG summary for the whole of the financial year, the average would be inconsistent with actual earnings.
Not wanting to be pedantic, but there is a clause in the Social Security Act about seasonal workers, and I cannot recall what it is, but I know that seasonal work, my recollection is that seasonal work is treated differently. So
Right.
if we could use a different example.
What about a university student who works on holidays and weekends and their work fluctuates around their studies and exams?
Yes, it may not reflect accurately what the weekly... So
Yes.
If it helps, Ms Campbell, I can tell you that on the 9th of March 2017, there was a first-tier AAT case of Jones decided, which involved a shearer whose work was effectively seasonal, and his debt was set aside on the basis that averaging of income from 9 different employers for him had made no sense at all. So it does seem that whatever the clause in the Social Security Act, people like that were caught by this scheme.
I'm not denying that, Commissioner. It's just that I don't have the Social Security Act here, and I just remembered there was something about the term seasonal.
Thank you.
And so many of the persons who receive Centrelink income support payments would have variable work hours and variable incomes as a general proposition. Would you accept that?
I do accept that there was a significant cohort that would have had variable.
And they would be, that significant cohort would be captured by the risk of the inaccurate calculation of actual fortnightly income by the averaging concept.
If they weren't able to provide that alternate information.
But they would be caught by the initial averaging, which was what created the discrepancy and led to the initial letter.
The trigger, the initial letter, and so yes, they would have been sent an initial letter.
That's right. So they're caught initially by an averaging process, and then if they don't respond for whatever reason, that averaging process crystallises in respect of that significant cohort, and the risk is realised.
And so I was particularly worried in those first days when it was rolled out that there hadn't been the opportunity for people to respond, that we hadn't ensured that people received the letter, which is why there were changes, and that the material wasn't clear enough on what was happening.
I think you're agreeing with the proposition that where people didn't respond, the risk of inaccurate calculations of fortnightly income would crystallise.
When people didn't respond, that's correct.
Yes. And that in those circumstances, it would be obvious, I suggest, that the allegation of a debt in a particular amount may well be unsustainable in fact.
Yes.
And that would have been obvious at the time of this proposal because of the recognised need for legislative and policy change.
This document, which was the initial proposal,
Yes.
and then there would have been a final new policy proposal that was agreed.
Yes.
Yeah.
But what I've just identified with you as crystallisation of a debt based on averaging not being supported in fact was an obvious feature of this proposal, which is reflected in the alert to the Minister for the need for legislative and policy change.
That was an alert, yes.
Yes. And the alert recognised the fact that averaging might not create, for a significant cohort, an accurate fortnightly income.
Yes.
And in some cases, that inaccuracy would be too high. That is, the averaging process would lead to the allegation of a debt which was much higher than it had to be or didn't exist at all.
Yes, and in some cases debts that were lower if there hadn't been,
Yes.
if there had been a manual process.
And the concept of averaging PAYG data didn't take into account other income which is non-reportable, as it were.
I'm sorry, such as?
Well, there will be some cases, would you agree, where the debt value identified under a smoothed approach would be too high because excess income over the fortnight disqualifying income level is currently ignored for single allowees, single pensioners, partnered pension couples, whereas it would be included in the smoothed approach. Would you agree with that?
I don't understand that, I'm sorry. If there's something that I could look at, I don't understand what's being asked.
Were you aware that in early 2015, a disqualifying amount for a single adult New Start recipient was $999 a fortnight, and for a single person on youth allowance under 18 years of age, it was $545 a fortnight?
I don't know whether it was those exact amounts. I knew that there was an amount at which a single recipient of New Start and a single recipient of youth allowance would not qualify for a payment.
And that there was a difference in those amounts?
There was a difference.
And that the averaging of income over a period might then lead to inequality between outcomes according to the threshold.
So my understanding is that when the averaging was undertaken, that it catered for different payment types. So, for example, the example that's just been used of a New Start recipient, that it would be applied to whatever payment had been the recipient had been receiving, and that would be in a different amount. So if they got youth allowance, it would have looked at the youth allowance threshold. If it was New Start, they would have looked at the New Start threshold. That was my understanding.
It may be convenient if I ask for, I'm not sure of the exhibit number, CTH.4000.0001.2141. It is an email trail which is now on the screen. And if we could go to the page ending 2143. Now, Ms. Campbell, there's no suggestion that you were copied into this email trail, but it is a document prepared by DSS in response to a proposal provided by DHS to DSS in late 2014, which became the proposal in similar terms of the 12 February 2015 executive minute. And as I recall your evidence from the previous occasion, you could not recall being shown any legal advice from DHS about the proposal.
No, I can't recall that.
And is that also the case that you can't recall being shown any policy advice?
No, I don't recall seeing this.
And so the reference to the change in legislation and the change in policy in paragraph 14 of the executive minute in attachment B reflects what you were informed, I take it, by Ms. Golightly.
Yes, that there would be a need, but not the detail of that need.
And I think you agreed with me last time, correct me if I'm wrong, that it was easy for you to identify what the legal advice was in what respect and what the policy advice was in what respect by asking for detail about that.
I think you put to me that I could have, and I said yes, I could have.
And it would have been easy to do so.
It would have,
Yes.
and depending on, I note that this is considered in isolation to other things that I may have been dealing with on that day.
If we can go over to page 2144. That is the next page, thank you. There are a series of dot points at the top, half of the page, 5 in total. And again, I'll just get you to read through these, Ms. Campbell. My question ultimately will be that these are unsurprising policy positions to be taken by DSS.
Is it possible to enlarge
Yes, perhaps at the top half of the
those
page
particular paragraphs? Or?
called out. Thank you.
I've read that material.
Yes. If we take them sequentially, the first one relates to review rights and says they're problematic. One of the issues under that heading is that if a customer did ask for a review, the debt would have to be investigated fully. That is, fortnightly income details obtained and the debt calculated in accordance to the law. Now, in accordance to the law, you would agree with me means the calculation of actual fortnightly income during the fortnight that the recipient received the supplement.
So councillors, we've already discussed, this is the first time I am seeing this document.
That's okay, I understand that.
So I am now being asked to go back to what my knowledge of the Social Security Act was, and I haven't worked in this space for some 18 months. This is a document I haven't seen. I didn't see at the time. I'm now seeing for the first time. So to go through the quite precise what the Social Security Act responsibilities are is not something that I am dealing with on a day-to-day basis. So I will answer to the best of my ability, but it is very difficult when this is the first time I have seen this.
All right. Let me ask the question this way. The entitlement the entitlement to income support supplement when you were secretary was based on actual fortnightly income,
We have agreed that in the past.
and in order to raise a debt, therefore actual fortnightly income needed to be proved to be exceeded. That is, the threshold needed to be proved to be exceeded.
Yes.
And to remind you of the evidence you gave previously about the purpose of legislative change, was that the core function of the proposed legislative change required to implement the measure related to the use of annual PAYG information as evidence of actual fortnightly information. Page 949,
949.
between lines 10 and 20, and your answer is at line 20.
So I knew that at the time of 2015,
Yes.
when the proposal to pursue this went forward to Minister Morrison.
That's right.
So I knew that at that point in time. I can't say that I retained that precision all the way from the 15th of January 2015 until today. I have refreshed myself with that. But whilst I knew it at that point in time, it wasn't something that I didn't go back to this brief every time we discussed Robo.
Having this knowledge about the requirement for legislative change in that context at that time, do you accept what's set out in the first dot point of the previous document, page ending 2144, that where a customer did ask for a review at this time under this proposal, the debt would have to be investigated fully, that is, fortnightly income details obtained and the debt calculated in accordance with the law, that is, proof of actual fortnightly income.
So I think in 2017, is that when we're talking?
No, this is 2015, January 2015.
In January 2015, I'm not sure I turned my mind to that level of detail.
Well, it follows from your acceptance that the key component of legislative change required under the policy was to equate PAYG income with actual fortnightly income, that the calculation of a debt according to law required proof of actual fortnightly income.
I appreciate that that's your position, that led from this, the paragraph I'm looking at for the first time, led from that statement, but I don't know that I had turned my mind to how a review would operate.
Given that your department had responsibility for policy advice in respect of the implementation of the ACO program, can you explain why you didn't turn your mind to potential difficulties with review rights?
So I think and the fact that DSS is providing this information, this related to the policy of the legislation, the enacting. And we will continue to have, I will continue to indicate that that's why we had relied on DSS to provide this policy advice as per the document on the screen. I had left that to the working through between the offices of DHS and DSS.
Well, what policy considerations did you give then to the implementation of the OCI program?
So when we say policy, and I think I said last time the word policy was very much debated between DHS and DSS. So for me, the policy of implementation was to ensure that customers, recipients, were able to access payments and were able to do that in a manner that facilitated their ability to comply with the legislation and the like. It didn't, policy which required legislation in the Social Security Act was something that DSS was quite focused on. I agree that that's a very hard concept to explain and for people to understand. And it was very problematic in its implementation because, as we can see, there were clear crossovers between responsibility between DSS and DHS.
But merely because DSS volunteered a policy position on a DHS proposal in respect of implementation and service delivery didn't relieve DHS of forming its own policy position in respect of implementation and service delivery, did it?
So I would suggest that this was not a DHS policy. This was a DSS new policy proposal. It was taken forward by DSS in the portfolio budget submission. DSS and DHS, and I think I said last time, in hindsight, it would have been better for us to have gotten external legal advice together to ensure that this had been achieved.
Well, it would have been better if DHS considered policy implications of the implementation of the OCI program too.
So, policy implications. Sorry, what do you mean by that?
Well, you have responsibility under the administrative arrangements orders for policy in respect of social security.
No, we don't. We had, if we could get those back, we had policy responsibility for service delivery,
Yes.
not the Social Security Act.
I wasn't suggesting the Act.
It's Social Security.
We're talking now only in respect of what is set out in the administrative arrangements orders
Yep.
in respect of the policy responsibility of DHS for social service delivery and implementation.
Service delivery, not Social Security payments. So we were responsible.
Yes, I know that. That's the context of my question.
So now I'm confused.
Well, as I understand your evidence, you didn't consider policy in respect of service delivery under the OCI program.
My evidence this morning.
Yes, a few minutes ago.
So I think your interpretation of policy and mine is different.
Can you say what the administrative arrangements orders mean to your understanding in respect of the policy responsibility of DHS in respect of service delivery and implementation of OCI?
Okay, so service delivery was ensuring that the program was delivered as per the proposal that had gone forward, that we were providing citizens with a service which was enabled them to meet their needs, and that we were abiding by the law. Now, we know that that was not the case, but DSS, as we have seen from the document that you had on the screen, was providing advice on the implementation of the Social Security Act as per this proposal.
Can I ask you this? You raised debts, and this is your job at DHS. You agree, raising of debts?
Yes.
on the basis of an entitlement in a recipient to income supplement on the basis of their actual earnings in a fortnight.
For some payments. For other payments, it's on an annual basis.
I think maybe age pensions, but we're talking New Start,
Family tax
youth
benefits,
allowance.
family tax benefits on an annual basis.
Right,
as well.
so, and these are the people that were the subject of the Robodebt scheme. So that was the basis on which you could raise benefits. There'd been some practice in the past, which we've discussed, of averaging as a last resort.
Yes.
But with this scheme, you were moving to just about automatic averaging if you didn't have a response. Wasn't that a change of policy to take this completely different, or sorry, perhaps not completely different, but this different approach?
So the intent was to get a response. The intent was to work with the recipient, to engage with them so that they would respond.
Well, never mind all that. Didn't it involve a policy change of how you would approach recipients?
It did involve a policy change in how we would approach them, but the intent had been that the recipient would respond and we would work with the recipient to respond.
And a policy change in how you would characterise their overpayments, how you would establish overpayments, because it was no longer a matter of looking at actual income and in some, it doesn't seem very many, but some cases averaging as a last resort. Now it was automatic averaging if there's no response. Is that not a change in policy?
So I think when we put the proposal forward that we've talked about in the February 15 letter, so that was when I looked at it, that it was that there was a policy change and that we would work with DSS on it. Between that letter and when the new policy proposal was agreed by government, something happened. I have found no evidence and I was not involved with it. I think and so at some point in time, a decision was taken that didn't require policy and legislative change. I am not sure where that decision was taken before it was agreed.
But I'm just asking you about the point at which you put the proposal to the minister. Didn't you think this is a policy change for us if we're going to start recovering debts like this?
And I think we reflected that in the brief we put to the minister.
Okay, so you did perceive a policy change.
I think in the brief that went to Minister Morrison, it said, in working with DSS, DSS have indicated that this represents a policy and a legislative change.
And you appreciated yourself, presumably, what those were?
No, I think I've given evidence that I probably didn't turn my mind in the level of detail that I now wish I had of, but that there was. So the brief that went forward said that there was, DSS have indicated that there would be policy and the need for policy and legislative change.
Yes, but there would also be the need for a policy change in your department, not just DSS, surely?
So when you say a policy change, I think the document that was on the screen not long ago indicated what DSS thought would occur, and it would have been an implementation change within services and within the Department of Human Services.
Mm-hmm. All right, which involved a policy change.
A policy change which would have been authorised by DSS, because DSS were responsible for, I can't remember what it's called now. There's a document, a guide.
Do you mean those operational blueprints?
No, that was DHS, but there was a guide to the Social Security or something. I'm sorry.
Guide to the Social Security law? Is
I
that
don't know. There was something that they had to, DSS was responsible for updating. I'm sorry, Commissioner, I don't have it. I'll look during the break to see whether I can find what it was called. But I have seen it in preparing, that there was, and that's how DSS changed. In fact, I think it's the Ombudsman report of 2019.
Okay, but can we get back to TORS? DHS had some policy responsibility for implementation
DSS was responsible for implementation.
and for policy around implementation.
It depends on how you define policy. So, yeah, DHS was responsible for implementing the program.
Mm-hmm. And the policy behind the implementation was DHS's responsibility too.
The policy, when you say policy, I suppose I'm just trying to understand what you mean by policy.
Well, these were the administrative arrangements under which you operated. which required you, or required your department to be responsible for service delivery policy.
Yes,
Part of the service delivery we're talking about presumably is your function of debt recovery if there's an overpayment.
in accordance with the Social Security Act, which was the legislative and policy responsibility of the Department of Social Services.
All right, I don't think we're getting very far. I'll leave it back to you, Mr Gregory.
Thank you, Commissioner. The matters to be dealt with by your department, I'll remind you of it, under the Administrative Arrangements Order, was the development, delivery and coordination of government services and development of policy on service delivery. You accept that?
I accept that was the Administrative Arrangements Orders.
Obviously, they were valid
Yes,
and they applied to your department,
they did,
of which you were the secretary,
of which I was the secretary.
which surely casts some obligation on you to ensure the development of policy on service delivery.
I think, Council, it's the definition of the service, the policy of service delivery.
Well, I'm just using the words of the Administrative Arrangements Orders. Are you prepared to accept they cast an obligation on you as secretary to ensure the development of policy on service delivery?
It did, but I think what you're asking, and there's a crossover in between the policy of service delivery and the policy of the Social Security Act.
Now, the policy on service delivery included the policy of recovering debts under the OCI scheme.
On recovering debts or establishing that there was a debt?
The policy on recovering debts was part of the service delivery under the OCI scheme.
So I suppose I'm still struggling with the concept of policy in the way you're asking the question, because for me, the policy of service delivery was the actual engagement with the individual. So if we're talking about the engagement with the individual and the IT systems and the officers and the customer service officers who were trained to do it, yes, that was the responsibility of DHS.
And the letters sent
And the
to
letters?
customers under the OCI program.
Yes,
That's the policy.
that's your definition of policy.
Well, it's yours. I just added customer letters to it.
See, I don't think a letter is a policy. I think it's an implementation.
Right. But that's exactly what you just described as areas of policy responsibility, engagement with a customer, and that surely must include letters under the OCI scheme.
So if we're talking about letters, yes.
Well, given that it was your responsibility or your department's responsibility to develop policy on service delivery, including under the OCI scheme and including letters sent to recipients, what policy development did you undertake in that respect?
This is before the rollout of the system in 2016.
Yes.
I was not involved with the letters.
What policy development did you engage in respect of the OCI program generally?
No.
None.
So I can find out how many letters were sent annually out of the Department of Human Service. There were hundreds of thousands of letters. And there were many, many programs that were running. And we talked last time I was here about the need for me to delegate some responsibilities to deputies and senior executive services officers within the department. And so no, I was not involved with the rollout of the online compliance initiative until concerns were raised in the end of December, the start of January 2017.
Coming back to this time in January 2015, when the DHS proposed to the Minister of DSS a particular measure which became the OCI program, what consideration did you give to the development of policy on the service delivery of the proposal?
I did not consider in detail at that point the service delivery policy.
Did you consider it at all?
Not that I can recall, no.
Why not?
Because there was a deputy secretary leading this, and there were many other proposals that I was considering at that time.
It was a significant proposal.
It was there were many significant proposals.
Are you saying it's not significant, or
I
are
am-
you accepting that it's significant?
I'm saying it was a proposal that was important, but there were many other proposals that we were dealing with at the same time. We were dealing with replacement of IT systems. We were dealing with changes to a broad range of programs. And I know that the dollar amounts are very large, but this was a very large amount of money that was spent in this space. And so it was a policy, and I think out of something like 40 other policies that went forward in that budget.
You said it was an important policy. Is there a distinction in your mind between an important policy and a significant policy?
No, but there were 40 policies, and I suppose I'm trying to explain that at that time it was one of many programs that I was turning my mind to, and I did not turn my mind to this one in the level of detail that allows me to answer your questions.
Or at all?
So there were 40 programs that went forward in that budget that were agreed in the budget.
I'm only asking you about this policy and whether you
And-
turned your mind to the development of policy on service delivery for the proposal.
No, I didn't.
Yes. That
Did
is,
any other of these proposals involve making demands on welfare recipients the way this one did?
So there had been compliance proposals. The entire time I had been the Secretary of the Department of Human Services that did require people to engage. There was a proposal that was rolled out at the start of 2013 with...
Okay, we're talking about 2015. You're saying there were 40 other proposals. Did any of them involve actually placing requirements on recipients as onerous as this, in the numbers this did? Was there anything of these proportions when it came to actual effect on people who received income support?
I can go back and look at those 40 proposals. I know at the time there was something about age pension, which impacted a significant number of people. But I'd have to go back and look at each and every one of those in order to be able to answer that question completely, Commissioner.
All right, well, I'm not sure if you have the means to do that over the lunch break, perhaps. Mr. Gregory?
thank you, Commissioner. Do you accept that in respect of the proposal, the review undertaken where a person sought to appeal the decision would result in a different calculation of a debt where someone compared to someone who did not seek a review?
Depending on their circumstances. So if there was a person who sought a review, and depending on the information that was provided as part of that review, versus a person who didn't seek a review and had the same circumstances? I'm sorry, I'm confused.
So someone has a debt calculated under this proposal based on averaging, which might be inaccurate for a large cohort of Centrelink recipients, but they don't seek a review. Their debt would remain as it was calculated according to those risks, correct?
And so this was in the first stages of the rollout?
This was under the proposal.
Under the original proposal, which wasn't the which the final proposal I'm not clear on, yes.
Right. And someone who sought a review would have an authorised review officer manually undertake an analysis of the information that was held.
Yes, and that's why the initial proposal was that the recipient was able to engage with the system.
And so there could be a real difference between the calculation of debts between those who sought a review and those who didn't seek a review. That is in the process.
And those who engaged with the system and those who didn't engage with the system.
I think you're agreeing with me, but to be sure, there could be a real difference in process, or there would be a real difference in process for someone who did not seek a review compared to someone who did.
This is on the assumption that they didn't engage with the original process, is that?
Either of them didn't engage in the original process.
That if neither of them engaged with the process and then there was a review, Depending on the information that was provided, each case would be different, but if they had, hypothetically, the exact same details, the exact same issue, if someone sought a review and was able to provide additional information, they might have a different outcome.
I'm talking about the process, not the outcome. Where someone engaged with a review, there would be a component of manual assessment by an authorised review officer.
That's my understanding.
And that wouldn't occur where someone did not seek a review.
That's my understanding.
And so there is a difference in process between those who sought reviews and those who did not seek reviews.
Yes.
And that would result in different treatment for those people in respect of the calculation of their debts.
And that was why we put particular emphasis in trying to engage with people before it got to that stage.
Again, I think you're agreeing with me, despite the manner in which you expressed your answer. That would result in the different treatment for people who seek review compared to those who did not.
On the assumption that those people had not engaged with the system before we got to the authorised review stage.
It's a yes on that assumption, I take it. The word yes is missing from your answer. If you accept the proposition with a qualification, you should say that.
Yes, on the proviso that it's clear that that person, the two people that you are talking about, had not engaged with the system beforehand.
Right. A potential inequality created by the OCI system.
I would suggest that that's a potential inequality from the social security system, because if people don't engage, sometimes if there's an opportunity to have a review, additional information can be brought forward, and so those people who seek a review, if we're going to categorise it as an inequality, the review does give that opportunity to bring forward additional information.
So you're disagreeing that a potential inequality from the change in process under the OCI system?
No, I'm not disagreeing.
You're not disagreeing with that?
I'm qualifying to say that when someone seeks a review, that provides an opportunity to bring forward additional information. And so therefore, there would be an inequality compared to someone who doesn't seek a review and doesn't have the opportunity to bring forward additional information.
That, of course, all turns on the fact that the system was designed around the transfer of the onus in the first place.
I was talking more generally about the Social Security Act.
Yes, my question only related to the OCI system.
So if someone seeks a review, there's a possibility of a different outcome versus someone who doesn't seek a review, because the person is able to bring forward new information at that review time.
Or they don't have to either, do they? They can just ask for a review and it happens.
They can, yes.
Again, you referred to the outcome, not the process. I'm focused on the process. A potential inequality under the OCI system was different treatment for people, between people who sought a review and those who did not.
Yes.
And that inequality was not something you considered in the proposal.
I noted, I did not turn my mind to it, but I note that if someone seeks a review, they do have the opportunity to provide additional information as part of that review.
What about the question of whether people were informed that the calculation of their debt, where they didn't engage with either of the two letters, would be done on an averaged basis under the OCI system? Did you consider that?
At what point?
At the point at which you made the proposal?
I didn't go into the detail in 2015 when the proposal went forward. In 2017, I turned my mind more acutely to that issue.
Because it had been raised from other sources?
Yes, and because it was the most pressing issue I was dealing with at that time, whereas this proposal was not the most pressing issue I was dealing with in 2015.
Does your attempt to ensure the department satisfies its obligations under the administrative arrangements orders depend upon how pressing a matter is at any given time?
My experience as a secretary was you only had capacity for so many issues, and you had to prioritise where your focus went because there was only so many hours in the day.
And so it might mean, sorry to cut you off, please finish.
And so I had put in place mechanisms where officers were delegated responsibility in order to do that.
Who did,
Necessarily, when something became very acute, I spent time focusing on that.
who did you delegate with the responsibility of developing policy around the OCI program?
Ms. Golightly.
And what did she tell you she'd done about that?
I don't recall.
Did she tell you anything to your recollection?
So I put in place a mechanism for monitoring the implementation of budget measures, which included a subcommittee of the executive committee to ensure monitoring of these. And I have looked at the documents with regard to this, and we had not identified the failings that proved to be the case in the online compliance initiative.
So you delegated the responsibility for the development of policy surrounding the OCI to Ms. Golightly, but you didn't follow up?
So I put in place mechanisms, which was the implementation committee, I think it was called, to monitor the implementation of measures. And I have reviewed the documentation from that committee, and it did not identify the shortcomings that were subsequently became evident.
That is, the committee didn't look at policy development for the OCI program?
No, I think the committee did not identify the problem. So you could say that they didn't look at that in that space, but the committee did not identify the problem that we had identified, that was subsequently identified.
Was that because the terms of the implementation committee didn't contain a reference to development of policy for the OCI program?
I think, so the implementation committee looked at the 40 or 60 measures that we were delivering, so it wasn't as specific. I don't have the terms of reference with me, but it was monitoring the implementation of the various measures that were being implemented across the Department of Human Services.
So the delegation didn't involve any specific reference to the administrative arrangement orders obligation?
No.
It would be important, wouldn't it, for someone who was the subject of a presumptive averaging, which identified a discrepancy, and a debt letter based on averaging, to be informed of the basis on which their debt was calculated?
Yes.
It would be fair to someone to let them know that, wouldn't it?
Yes.
It would be transparent and accountable and clear about the department's decision making.
Yes. Can I just clarify? Are you asking about the initial letter or the subsequent debt letter?
Both.
Okay, yep.
Right. And to your knowledge, under the OCI program, people were not told that their debt was calculated either in the presumptive discrepancy stage or finally on the basis of averaging.
And the initial rollout had a number of concerns like that, and that's why there were changes were made from January 2017 onwards.
Again, I think you've agreed with me.
Yes, I have agreed that the initial rollout, there was significant shortfalls, and I think in my statement I indicated that I was concerned that procedural fairness had not been afforded to individuals.
And that would make it difficult for someone to know when to exercise their appeal or review rights, wouldn't it? Because they wouldn't understand how the debt was calculated.
And that's, yes, and that is why the changes were implemented from January 2017.
Did the changes from January 2017 communicate to recipients in respect of the first or the second letter that the debts were calculated according to income averaging?
I don't know now. I haven't gone back and accessed every letter that was developed during that phase.
Right, we might come to it after the morning tea break. Were you concerned in a policy sense also? Sorry, I'll withdraw that. Would you accept that in a policy sense there was a reversal of the onus of proof by the development of the OCI program?
Yes, we discussed that last time I gave evidence.
Were you concerned that were the proposal to be implemented with the reversal of the onus the potential inequality between those who sought reviews and those who didn't, the risk of overcalculation of debts from averaging, that if that was challenged, it might cause reputational damage to the department.
I did not consider that at that time in 2015 because the proposal that was put forward asked the Minister to pursue this activity, and it indicated that there would be work done with the Department of Human Services and the Department of Social Services on this proposal. I then did not see the final proposal as it was identified.
But it was obvious to you in early 2017 that the final proposal, as DHS implemented it from 1 July 2016, reflected the core components of the proposal as it was in the 12 February 2015 minute.
Yes, but there were shortcomings in the way it had been rolled out, and I then worked with the area as well as with the Minister to rectify those shortcomings, particularly in light of the legal advice provided by the Department of Social Services in responding to the Ombudsman report about the use of averaging.
In January 2017, when this issue was front of your mind, did you then take steps to ensure that the department discharged its obligation under the administrative arrangement orders to develop policy in respect of the delivery of the OCI?
So, develop policy, I don't know whether I would have called it develop policy, more so in implementing policy to ensure that the procedures and the letters and the ICT system and the engagement with the citizen was so that procedural fairness was afforded to the citizen.
You're referring there to informing persons that their debt is calculated by means of averaging?
I'm referring to the fact to clarify that the recipient had received the letter using mechanisms such as registered mail and checking that there was a read receipt on a MyGov document, that there was a contact phone number where people could contact a person, a staff member of DHS, if they were looking through those issues, that people could use bank statements rather than pay slips to help facilitate the rollout of the program.
None of those features address the risk of overpayments or underpayments and the calculation errors, though, did they?
So I was working off the advice that had been provided in January 17 as part of the Ombudsman report, that averaging could be used as a last resort. In fact, in preparing for these statements, I note that there's a brief to Minister Tudge in August of 2017 that said averaging hadn't been used to that point because we were trying to engage with the recipient in order that they could give advice about the amounts of money so that we could avoid using averaging, and that it would only be used as a last resort. And so the focus I had in the first months of 2017 was to make the system user-friendly and allow recipients to be able to engage with the system.
Surely that advice to Minister Tudge was wrong, though, because averaging had been used prior to late 2017.
So the advice talked about from January, so at a point in time we hadn't raised debts from January 17, I don't know what the date was, debts had not been raised using averaging without engagement with citizens. So at that point we thought if a citizen said, I am comfortable with averaging, it was okay to use. We now know that that was not the case. So
no one ever said they were comfortable with averaging because they didn't know up to that point.
the time frame is this January 17?
Yes, through to August 17.
Oh, okay. So you're saying that the letters were not clear enough or did not indicate the averaging?
I'm saying that even when this issue about the criticisms of the OCI policy were front of your mind in January 2017, you did not address your administrative order obligation of the development of policy on service delivery of the OCI program.
I don't accept that.
You didn't turn your mind to the development of policy in respect of the over-calculation of debts and that risk?
I did. I did turn my mind to that by working through the system to ensure that a recipient had the opportunity to engage with the system. And that was my focus.
But irrespective of whether they had the opportunity to engage with the system, many people did not engage with the system, correct?
I know that, yes.
You knew that in 2017.
And we strove...
As a yes, you knew that in 2017?
I knew in 2017 that people had not been able to engage with the system.
Or chose not to?
Which is why I worked diligently to work out how we could get people to engage with the system.
But why does it matter whether they can engage or not, where a significant number of recipients did not engage and debts were calculated according to averaging, which might be too high?
Because the legal advice that we were provided by the Department of Social Services at the start of 2017 said averaging could be used as a last resort. And so I didn't want to use averaging as a last resort. I wanted the citizen, the recipient, to be able to engage with the system and clarify what was going on.
Didn't it trouble you that using averaging might lead to the calculation of debts which did not exist in whole or in part, irrespective of legal advice about their validity?
So, did it trouble me?
Yes.
So I was troubled that citizens weren't able to engage with the system.
Why was that more important to you than the concern about the prospect that averaging might create debts which didn't exist?
Because I didn't want to use averaging. That's why.
And why didn't you use it? Then why did you use it?
Because the legal advice said that we had received from DSS that averaging could be used as a last resort. And so we didn't want to do that, which is why we worked hard to ensure that the recipients could engage with the system and work through it. And then we would only use averaging as a last resort. And in fact, I don't think we used it from early 2017 until August or September of 2017.
It was a new automated system which had averaging as its centrepiece, correct?
Averaging was the trigger point but that had been the case with all PAYG compliance initiatives, whether they be automated or manual. So PAYG, if when the manual compliance systems were in place, and I think that had occurred for an accelerated number of those that had occurred in the year before the OCI rolled out, that was the trigger to seek a compliance review.
It was more important to you to get people to engage with the system rather than accurately calculate actual fortnightly income.
No, I didn't say that.
Well, I'm suggesting that's the effect of your evidence.
Well, I have given evidence that the initiative, and from January 2017, when I was closely involved with this initiative, was that we sought to engage with the recipient.
I'm not suggesting that's not right. I'm suggesting it was more important to you to do that than ensure that debts were accurately calculated.
Debts weren't being calculated using averaging during that period.
During 2017?
At a point in 2017, my understanding is that we weren't using averaging to calculate the debts. We put that on hold while we were working with the system to allow the citizens to engage. And then there's a brief, I think in August of 2017, which says to the Minister, we have this amount of people which we cannot get to engage. We're going to have 2 genuine attempts, phone calls, and it goes into the details about phone calls and contact and using other sources of data such as the tax office to find their phone numbers to try and get people to engage. And only then would averaging be used.
Yes, but it might lead to an inaccurate calculation of a debt for a significant cohort of those who didn't engage.
Yes.
Why wasn't that more important than trying to get people to engage?
Because we were trying to get them to engage, so then it wouldn't happen because we would get them to engage first.
See, is that a convenient time?
It is. We'll come back at 5 to 12. Jess, come here.
All rise. Commission stands adjourned until 11:55. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Yes, thank you, Commissioner. Ms Campbell, I'm not sure if I misled you in the course of the morning session or you agreed with something that might not be true. How sure are you that averaging was used to create the concept of a discrepancy for the purpose of the initial letter?
That was my understanding.
So that I'm clear on your understanding, what do you say to the proposition that it was the gross income reported to the ATO compared to the gross income reported to DHS, which was the source of the discrepancy, rather than an average of the ATO?
So my understanding was it was the gross income that was reported to the ATO divided by the period that had been reported to the ATO as compared with the gross income that had been reported to DHS by the recipient.
Are you saying that that's the process which leads to the initial letter rather than the final debt calculation?
That's my understanding.
Okay.
It
And-
certainly is not what was said in the initial letter, is it? The initial letter would just refer the recipient to the gross amounts. Is that not right?
I'm not sure, Commissioner. I'd have to refresh my memory with looking at those letters.
All right.
And I think, so I'm just trying to recall, and then it was compared to what the thresholds were for the actual payment. So, for example, if a recipient had declared, say the threshold for that fortnight was $500 and the recipient had declared $300, but the tax office data suggested $400, that wouldn't have mattered because of the thresholds. But I can't recall now how that exact method worked.
All right. Thank you.
In any event, there is little dispute that one of the changes to the OCI system compared to the previous manual system was that the PAYG data was the trigger for a comparison which led to the initial letter rather than a manual assessment.
My understanding is the manual assessment used the PAYG data as the trigger for the manual assessment.
And under the OCI program, the PAYG data was used as the trigger for the initial letter.
Yes.
That is a change to which reflected the evidentiary significance of the PAYG data.
So the change was that in the past that had triggered a compliance review, and in the new system it triggered the initial letter.
And that's because of the change in approach to the weight placed upon PAYG data in the new system.
That change was to accelerate the number of reviews that was occurring.
Yes. And
that if the recipient had responded to the initial letter and provided information, that was information would be taken into consideration.
And if they didn't, the averaged PAYG data was
used.
proof of the debt.
Was used, and that was why we sought to change the system in January 2017 to ensure that people had the opportunity to engage.
Yes, but even with the changes you keep referring to in 2017, PAYG data was capable by itself in an averaged way of proving a debt under this system.
If the recipient had not responded, and I think I gave evidence before the break that we didn't do averaging for a period of time, and then there was a brief in August of 2017 that indicated sought agreement to proceed with that methodology.
And everybody who had been in the system at that point, in respect of whom averaging had been paused, was then captured again.
My recollection is that those people who had not engaged with the system were reviewed. And I can't remember whether we wrote to them and said, would you like a review? Here is how to do the review. So those people who'd been captured from 1st of July 16 through to then, if they hadn't engaged with the system, there was an opportunity to review.
Yeah, all it was, though, was a pause. It's not as if averaging stopped altogether in respect of any given customers.
No, Commissioner, but it was paused to put in place mechanisms to allow for better communication with the recipient and to offer the recipients the opportunity to review.
Right, thank you.
If I could have Exhibit 1286, RBD.9999.0001.0022, it's the excerpt from the 2016-2017 annual report, which you completed, I think, just before taking up the role as Secretary DSS. And if we go to page 001, the second page, and pull out the heading Potential Overpayments and the first two paragraphs. Thank you. Now, Ms Campbell, if you could just read that again to yourself.
Yes.
There is a reference in that paragraph to the guidelines on data matching in Australian government administration issued by the Office of the Australian Information Commissioner. What role did you understand those guidelines to have in respect of the OCI program?
I don't now recall.
Do you recall satisfying yourself at any point of the accuracy of that paragraph in the annual report?
I don't now recall.
Did you understand at least that data matching between DHS and the ATO while you were Secretary was regulated by some guidelines and some laws?
I recall there were some arrangements, but I don't know what they are in detail at this time.
When this issue was front of your mind in January 2017, that's about 7 or 8 months before this report was finalised, did you give any consideration to whether the DHS was complying with its obligations under the data matching guideline?
I can't recall. I do remember preparing for Senate hearings, but I can't recall specifically that matter.
Do you recall whether there was a data matching protocol placed in public view on the DHS website?
I remember something about a data matching protocol, but I can't remember the detail.
Do you recall if you delegated responsibility for ensuring compliance with data matching guidelines and laws generally to anyone?
Explicitly within the delegation structure? I don't recall doing that explicitly, but I would have expected that the Deputy Secretary responsible for compliance would have been involved in that activity.
And does that Ms. go lightly?
It was.
Do you recall ever asking her to confirm that all the dots were in the right place and the T's were crossed in respect of data matching for the OCI program?
I can't recall. I can't recall a discussion about that.
Do you have any recollection of turning your mind at any time to the significance of data exchange between DHS and ATO under the OCI program?
I can't now recall. It has been some years.
And looking through all of the documents you've been able to access, you don't see any reference to consideration of this issue?
Not in the documents I've considered, no.
Would you accept that had the guideline been complied with or the OCI carried out in accordance with the guideline, that there would have been a technical review of the process required by
I
the
don't-
DHS,
I don't know.
and the publication of a detailed statement on its website about the way in which the data was being used.
I don't know.
At the bottom of the page, there is a reference in the report to online compliance, and we took or drew attention to this at your evidence on a previous occasion. You'll recall that the introduction of the online portal did not change how data matching was undertaken or the way income was assessed and differences calculated. Was the subject of some questioning last time.
I do recall.
I suggested to you that it was positively misleading, and you said that it was incorrect or could have been phrased better.
I did.
What would be the correct phrasing for how the introduction of the online portal changed how data matching was undertaken, the way income was assessed, or differences calculated?
So, and this is not the exact words I would use if I was rewriting the annual report of 2016-17, but I would say that the initial trigger for compliance reviews had not changed, that there was a discrepancy detected between the material that had been reported by the recipient to DHS and had been reported by the Australian Tax Office. What had changed was the use of a online system and the requirement for the recipient to engage rather than the compliance officer engaging with the recipient.
Would it also be correct to say that the difference or discrepancy identified from PAYG data brought about a difference because it was used as a trigger for a letter rather than a trigger for a manual review?
I thought that was what I had just said, I'm sorry.
All right. And would it also be correct to say that that income was assessed by means of averaging where people did not respond?
So, I had understood that with compliance reviews, the manual compliance reviews, on some occasions, averaging had been used there when the compliance officer had not been able to contact the recipient. I think I gave that, yeah. So I had understood that in the past, averaging had been used for compliance.
Where did you get that understanding? Because we don't seem to have found any documentation for that.
So I understood that there were some cases there. I know in 2019 there was a check to go back that there had been some cases found where averaging had been used.
But averaging where somebody hadn't responded, I'm not
Yeah.
interested in.
So I don't know whether that's a difference between when someone hadn't responded or when someone had responded and said averaging, agreed to use averaging.
Well, you see, Mr. Birra gave the example of a situation where somebody was missing 3 pay slips and accepted that their income would have been uniform, and so averaging was acceptable in the context of maybe 6 months where their income was demonstrable. So that's one instance in which you might use averaging. But the idea of using averaging just where someone hasn't responded is quite different, and it would be interesting to know what evidence there is of that actually taking place.
My recollection is that I was advised that averaging had been used in the past.
But in what context? Do you know that?
I don't know that.
Okay, thank you.
And do you know by whom? Who advised you that?
I can't recall.
And do you know when you were advised that?
I can't recall.
You've not found a document which records that advice?
No, and I have searched and I have asked DSS and Services Australia to search as well.
Well, the minute which you worked through with Ms Golightly, the executive minute, 12 February 2015, recorded that the proposal would introduce a new approach to reconciling information declared to DHS by the customer with information from the ATO. At least then, your understanding was that it was a new approach.
It was in the proposal to pursue.
And the documents that you've been able to review don't indicate any change to that concept of reconciling information declared by the customer with information from the ATO.
The only document that I've reviewed that would have changed my understanding of this was the legal advice provided by DSS to the Ombudsman that averaging could be used as a last resort.
Right, but it wasn't used as a last resort under the manual compliance process, was it?
Under the manual, my understanding is it had been on some occasions used in the manual process, and I don't know how I have formed that understanding, but that was what in my mind didn't, the advice that came from DSS in January 17, that averaging could be used as a last resort, I had understood that was compatible with what had been done in the past for the manuals.
Can't have been the case that you were aware of this advice that averaging had been used in the past as a last resort at the time of the February minute, though otherwise you wouldn't have described it as a new system, I understand.
I'm not sure I turned my mind to that detail because the brief said that we were going to continue to work with DSS on these matters.
Well, you had certainly turned your mind to the fact that it appeared to you to be a new system.
That was the advice that we gave at that time, but
Based on your understanding at that time,
based on what I'd been advised at that time and
which informed your understanding at that time.
informed my understanding at that time.
Right. And the other change, which you record in your minute, was the shift in obligation to the customer under the new system.
Yes.
And it would be accurate or correct to describe that change here in the report, wouldn't it? If you were seeking to describe accurately how the online portal affected data matching, assessment of income or calculation of differences.
Yes, Councillor, and I think in my answer a few moments ago I said that would have been, maybe I didn't articulate that as well, but I thought I had said that would have been one of the things that I would have, in redrafting it now, would have said.
And the third thing, in case I've misunderstood your answer, would be that the digital process, that is the online portal, and reliance on ATO data as a primary evidence rather than just a trigger, was relevant to how income was assessed and differences were calculated.
So earlier I said that I thought I would put in there that digital system would be used rather than a compliance officer. I did say that.
Yes, no, you didn't say that relying on ATO data as primary evidence rather than just a trigger was a change.
I'm happy to look at what I said in the transcript, or I can try and explain it again, but my concern by doing that is that I might not use the exact same words, that the data from the ATO would be used as a trigger to send a letter identifying that there was a difference and asking the recipient to engage with the online system to provide alternate information.
But income is assessed under the OCI scheme according to reliance by DHS on ATO data as primary evidence.
So this is the 2015 brief?
Yes.
So the 2015 brief put that forward, the way the online compliance initiative was established was to give the recipient the opportunity to engage with the system, to provide alternate information if there was something, and to ask them to check the ATO data. And then if they didn't respond in those first, when the letters weren't that flash in the first few months and they were unable to engage, there was averaging. And then in 2017, significant efforts were made to change that approach to facilitate the recipient being able to engage.
My question relates to the change adopted by DHS in respect of the primacy of ATO data under the OCI system. You accept that that was a change?
So if the recipient didn't engage,
Yes.
yes.
An obvious and significant change.
If the recipient didn't engage, but I also said I thought there were some instances in the past with the manual system where averaging had been used. And that view was reinforced to me by the DSS advice in January of 17 that averaging could be used as a last resort, which is why I became fixated on making sure that the recipient was able to engage with the system.
But if it were really going to be a last resort, DHS would use its powers with employers, for example, to get the information. You can hardly say it was a last resort just because you'd asked the customer and they hadn't responded.
That was how we interpreted it at that time, Commissioner.
That an absence of reply meant that you could then say, oh, well, there's no other option, we will average.
So I think the brief to Minister Tudge in August of 2017 indicated the steps that we had gone through and that there would be two, I think the term was genuine attempts to...
Yeah, I understand all that, but the point is that there are other measures you could have taken even on this last resort approach, such as asking the employers or perhaps going back through the person's social security file to see if there were separation certificates. But it doesn't seem that those kinds of steps were being taken.
It might be worthwhile me seeing if I can find that document in 2017, because I think there may have been some reviews of the social security file, but no, not the engagement with the employer.
Right, well then it wasn't a last resort, was it? Because you could have done something else to find out the facts.
Those actions could have been taken, yes.
Okay, thank you.
And the fact that those actions were not taken was a significant change in the way debts were calculated.
Yes.
And that's not reflected in the annual report, is it?
I think, no.
The annual report conveys that there has been no change to how the way income was assessed or the differences were calculated.
I thought I had earlier agreed that this was not the best wording of this document.
Well, it's not a matter of best or better. It in fact conveys a position which is not factually accurate. Correct?
Yes.
So the factual inaccuracies of this statement are at least three in number. The first is the significant change in the transfer of the obligation from Centrelink proving a debt to a recipient proving an entitlement. The next is that the significant change that ATO PAYG data is not merely one piece of the evidentiary puzzle anymore, but it has primacy as a trusted source under an averaging approach. And thirdly, that averaging is no longer a last resort because none of the powers that Centrelink can undertake to gather evidence on its own behalf were being exercised.
Those are the changes I identified. Yes.
And they're three significant changes, aren't they?
Yes.
And this communicates the opposite, doesn't it?
This does not communicate as accurately as I would if I wrote it today.
Well, it's so inaccurate that it communicates something very different. Would you agree?
I agree that this is not an accurate reflection of, and it could have been written better.
The extent of the inaccuracy means that someone is under the impression that nothing has changed compared to 3 significant changes occurring in respect of the way income is assessed and differences are calculated.
What was your first question, sorry?
The inaccuracies are so significant that when one reads this, they're under the impression that nothing changed, when in fact the way income was assessed and differences were calculated had changed significantly.
That there were significant changes, and this paragraph does not accurately reflect those significant changes.
It communicates there were no changes at all.
I think it does. There is a communication that there are changes there, but I accept that it's not accurate.
What changes do you think are reflected in that sentence?
In 2016-17, the department introduced an online compliance portal consistent with community expectations, that people could be able to review, update and confirm their information at a time convenient for them.
All right. I'm talking about the sentence below that. It communicates there's no change on the way that income was assessed. Correct?
So is it the element on the way income was assessed?
Yes.
So I think it's fair to say that income, for those people who did not engage with the system, that income was assessed using averaging, where in the past there would have been different mechanisms used.
And the way differences were calculated under an averaging-based system was also a change.
Differences calculated. So,
A debt.
so
The
I
way a
had,
debt is calculated under OCI using averaging is different in the OCI system. For
So
the
I-
3 reasons we've identified.
so I interpreted differences as the initial trigger for either manually engaging in a compliance system or sending one of the initial letters. I didn't interpret differences calculated necessarily as the debt, but I understand that there could be some confusion there.
Well, where is debt referred to in the concept of online compliance then?
I'm sorry, Council, I thought you introduced the word debt.
What you're saying is that the word differences is not equated with debt. Is that right?
I'm saying 5 years on, my interpretation of this sentence would be difference would be the either the trigger for the initial letter or the trigger for a manual intervention, not necessarily the debt. I can't recall what I understood to be differences in September of 2017.
Well, if you go back to the first sentence, data matching, step 1, sending letters, step 2, and assessing and calculating differences in income and payments, step 3 plainly refers to the calculation of differences which might lead to the creation of a debt.
That might lead to the creation of the debt.
Yes, that's the whole point of calculating a difference, isn't it?
So to engage, so the difference then engages with further consultation with the recipient, but not necessarily a debt, is my interpretation of that paragraph.
Do you accept that no matter what interpretation you now try and place upon it, that sentence communicates to the public that there was no change to data matching or the way income was assessed and differences were calculated?
Yes, and I thought I agreed that earlier.
And you now accept that that was inaccurate or incorrect because there were changes to the way income was assessed and differences were calculated.
The way income was assessed for those people who did not respond. Yes.
And the way differences were calculated.
For those people who did not respond.
Yes. And that is not addressed here, is it?
No. And I did think I had initially said at the start of this questioning that in hindsight, I would draft this paragraph differently. I probably don't expect I wrote this paragraph. I expect someone wrote it and I reviewed it, but I don't think I had time to write the entire annual report.
You would agree that without reference to the differences in the way income was assessed under OCI and the way that differences were calculated, this paragraph is misleading.
I have said this paragraph is incorrect, and so misleading is another term for incorrect for me.
All right.
There's another change that's not mentioned, and that's that you're going back 5 years with the data matching, and you'd never done that before.
I can't recall now, and I'd have to go and look, Commissioner, at the documents about what we'd done with manual checking before then.
You don't suggest you'd done it retrospectively over anything but the current year, do you?
I can't recall. I haven't looked at those documents, and those documents, I would have to go and call for those documents to have a look.
Okay, thank you.
Perhaps if on that point we can go back to the complete copy of the executive minute. CTH.2004.0002.2506.
Is this the one that was referred to earlier? Because I believe the witness now has a copy of that.
We could go to page 10 of the document, ending 2515. You'll recall that I asked you a number of questions about this last time, Ms. Campbell. But the first paragraph identifies the proposal is to introduce a new approach. The second refers to the analysis of PAYG data for the 2010 to 2013 financial year. Particularly that there are 866,857 customers with likely incorrect payments. And in the fifth dot point, the proposal refers to a 4-year measure to undertake that number of interventions for customers at risk of undeclared or underdeclared income from employment, with an anticipated saving of $1.2 billion in gross terms. And if we then go to page 15 of 17, paragraph 22 could be called out. What was communicated by the minute was that the department cannot ignore the fact that there is a stock of payments already in the system which are likely being paid in error. And of course, reference is made to the opportunities to address it outlined in attachment A, to which we just referred. This very clearly communicates that these were interventions which were not undertaken in the financial year in which the recipient received the money.
Yes.
The department is going back a number of years to conduct these interventions as part of what was described in this minute as a new proposal.
Yes.
And so that is the additional feature not referred to in the annual report to which the Commissioner just referred you to, that not only were the interventions new in other features, but there was a proposal to go back in time.
Yes, and when I answered the Commissioner's question, what I was trying to indicate was that it wasn't sure to me whether some other measures when we had done compliance had also gone back in time. And if they had gone back in time, they would therefore not be in this group because they would have been corrected. So what I was trying to say was that it's not clear to me whether we only ever did the previous financial year or a financial year once the tax information became available. And I note para 22 talks about when left, such payments can continue for long periods of time. That kind of implies that that the payments were continuing. So not just what had occurred in the past, but was in the future.
Now, as you understood the situation at the time the executive minute was finalised for Minister Morrison, without a change to the proposed use of PAYG data as evidence of actual fortnightly income, or at least a change of legal advice about that, the proposed system was unlawful.
I understood from that brief when we asked Minister Morrison to pursue this proposal is that we would work with DSS on the proposal, and DSS had indicated at that point in time that it was likely that it would require policy and legislative change.
And, sorry, go on.
And then there was a new policy proposal that was provided to Minister Morrison, which I was not privy to, that didn't include legislative change.
Yes, but as you understood things at the time of this minute, without a change to the way that the PAYG data would be used, or a change of legal advice about its proposed use, that the proposal would be unlawful in that respect.
So 2015.
Yes, at the time of the executive minute.
So I didn't, so what, we put that minute up and then a final proposal was agreed. And I was not privy to that final proposal, and then we implemented that final proposal. So I don't know that I turned my mind to determine whether it was illegal until 2017 when I said, hey, when we originally looked at this, we thought legislation was required. What happened? And I was advised that once DSS understood that recipients would have the opportunity to engage with the system, that DSS had then formed the view that legislation was not required. I know that to be now flawed, but I suppose what I'm trying to communicate is what I understood at the time of these documents.
That's all I'm asking you, is what your state of mind was at the time that the executive minute was finalised.
That I thought we would work with DSS because DSS had told us that it would require legislative change.
Yes. My question was, you understood the position to be that without a change to the proposed use of PAYG data as primary evidence of actual income, or a change of legal advice, that the proposal would be unlawful.
So I understood from the brief that we would need to work with DSS on policy and legislative change. I didn't turn my mind to whether the legal advice changed or that, but that was the position I understood when this brief went up.
You understood when the brief went up that the core function of the proposed legislative change required to implement the measure related to the use of annual PAYG information as evidence of actual fortnightly income.
So what was in the brief in 2015 I understood to be the case.
You're not answering my question, I'll ask it again. You understood the core function of proposed legislative change in the brief required to implement the measure related to the use of annual PAYG information as evidence of actual fortnightly information.
Can I just clarify which paragraph we're talking about at the moment?
I'm talking about evidence that you gave on a previous occasion.
Okay.
If you'd like to see it, it's page 949. lines 10 to 20.
So at the time that brief went up, I understood that that was the case.
And it follows from your understanding that legislative change was required to implement the measure in respect of PAYG information as evidence of actual fortnightly information, that without legislative change, it couldn't be used that way.
I understood, as described in that brief, that legislative change, DSS had advised us legislative change would be required.
I know that you've just said that, and I've just asked you about that. I'm asking you what follows from that. And that is, without legislative change, the PAYG information could not be used in the way in which the proposal said it intended to use it.
And I think I'm saying is that I didn't turn my mind to that next follow-on point because I had expected that to be sorted in dealing with DSS and DHS dealing to get the new policy proposal up. And then in 2017, I turned my mind to that and I then received the advice from DSS that said that it was able to be used as a last resort.
You received the advice?
I can't recall whether I received it or not. I have since seen it, so that indicates to me that I must have received it because otherwise I wouldn't have been provided with it as I prepared for the statement.
Right. What you're saying is, despite your understanding there about the need for legislative change required to implement the measure in respect of the use of PAYG information, it didn't occur to you that without legislative change it might be unlawful?
I didn't turn my mind to it because I wasn't focused on the legislative change.
But you ought to have been, because it was your responsibility to ensure the lawfulness of the delivery of the OCI program.
And I have previously said that I wish I had done it, but at that stage I had relied on DSS.
It's not a matter of wishing or not wishing, it's a matter of obligation. You ought to have been concerned about it because of your obligation.
So the way DSS and DHS worked at that time was that DSS was responsible for the legislative change.
You know that Ms Wilson's evidence was that DSS was given to understand by DHS that there wouldn't be any averaging, and that's why there was no legislative change required.
I'm not aware of Ms Wilson's evidence. I've been instructed not to read.
Did anybody put that to you at any stage that really DHS had misled DSS into thinking that averaging just wasn't going to happen?
That has never been put to me, Commissioner, no.
Okay.
We could go to page 961, lines 38 to 47. Lawfulness of the implementation of the OCI program remained DHS responsibility, correct?
Lawfulness of all implementation was DHS responsibility, but we weren't responsible for the legislative change.
And so it ought to have been on your mind to ensure that the implementation of the proposed OCI program was lawful.
And I think so with all the programs that were run by DHS, I did primarily rely on the policy department on the lawfulness of those programs, that the legislative change had been implemented to do that. I did not ask for legal advice to be sought on the lawfulness of this measure because I had relied on DSS, and that's demonstrated by the fact that we relied on them in January 2017 to provide that advice to the Ombudsman.
No, you didn't rely on them in January 2017. You gave evidence earlier that you found out about it from the report. You didn't ask for it in January 2017. And even if you considered getting legal advice by DHS in 2017, you didn't.
That's because DSS had provided that advice.
Well, it depends when they provided it, I guess. But the question remains, and I don't think you're answering it. It was DHS responsibility to ensure the lawfulness of the implementation of the OCI program.
Yes.
Surely, given your responsibility for the implementation of a program which sought to recoup $1.2 billion from people over 4 years, you would make sure that you discharged your responsibility to ensure that it was lawful.
So we relied on DSS. I now consider that to be unwise and that we should have sought legal advice as well. But I can only say what I relied on at that time, and that was on DSS to get that advice.
And did you make sure that DSS knew precisely what was involved in this program when relying on them for advice?
Personally, no, but and I've had a quick look at how many measures we did have. That's why I relied on others within the department to work with the various policy departments on the implementation. I couldn't possibly have been able to sit down and work through each and every program that we ran in such a large department. I had to rely on others to do that as well.
Saying that DHS delegated its responsibility for ensuring lawfulness in this respect to DSS.
So if we look at the administrative arrangements orders for...
I'm looking at your evidence,
and
what you've said, and the answer you just gave to the Commissioner, which was you relied on DSS. And I'm suggesting to you, you've delegated the responsibility to DSS then.
I don't agree.
But you took no steps yourself to discharge the responsibility you accepted, which is on the screen.
So I've explained that DSS, as the entity responsible for the Social Security Act, was responsible for legislative change. And legislative change was not made. So I had assumed that I hadn't turned my mind to that.
I don't ask you about legislative change and whose responsibility that was. I'm asking you about the discharge of your obligation to ensure that the method of implementation was lawful. And your answer to the Commissioner was that you relied on DSS to do that. And I'm suggesting it follows you delegated your responsibility.
And I don't accept that.
Because you did what, personally?
Because I relied, well, personally, and I have explained that unfortunately, personally, I could not do every program that was delivered by DHS. There were hundreds and hundreds. So I was unable to sit down and go through every one of those. So therefore, I relied on staff within the Department of Human Services to work with the agencies on whose programs we were delivering.
What did the department do then to discharge its obligation?
I have been unable to access documents that detail what other officers within the department did because I've only been able to access documents to which I was originally saw at the time.
So it follows from that answer that at the time you did not satisfy yourself of the lawfulness of the method of implementation of the OCI program.
No, but I can't say that another officer within the department didn't.
Taking a very big risk as a secretary, not satisfying yourself of the lawfulness of the implementation of a new policy proposal, aren't you?
So if there are many new policy proposals, and there are some 40, I didn't have sufficient time to go through every single one and work with every other portfolio we delivered programs for to determine what those issues were. I necessarily relied on 8 deputy secretaries across a department of 35,000 people to work with those people to ensure that this was the case.
You took a calculated risk in the context of a large volume of work that it would get sorted out.
don't think calculated risk is the right way to describe it, and they wouldn't be the words I would use. It was necessary to delegate to other people some responsibilities in order to run an organisation that large. And so, no, I did not personally seek legal advice to ensure that this program was lawful.
I mean, you can't say who did in your department.
I can't say who did because I'm not able to access any other documents.
The Commissioner asked you a question about what representations about the policy and its nature were made to DSS.
Well, I actually asked what they were told about the
What
actual
they were told,
program.
yes, about the program. Were they told the same thing as was reproduced in the annual report in 16-17, that there'd been no change to the way income was calculated or differences were calculated?
I don't know because I haven't been able to access any documents between anyone that wasn't me at that time.
If that was said, you would agree that it was misleading in the way that you agreed the 16-17 report statement was
It's
misleading.
hypothetical, I can't say what happened.
If that was said, you would agree that it was misleading in the way the 16-17 report misled people.
I don't know what was said, so I cannot comment on what was said.
Well, you were involved heavily in the costings for the new policy proposal.
I was involved in the costings of the departmental expenditure for the Department of Human Services. I was not involved in the costings of what we call the outlays, which is the debt amounts from individuals.
Surely you saw DSS costings on those figures though.
I have found no evidence of that, and that was not the normal practice between the Department of Social Services and Human Services.
Is it your evidence that you were closely involved with Ms Golightly in the development of the executive minute and this critical proposal in it, but then never saw the final result which made its way to Cabinet?
I saw the measure as published in the budget papers, but the process during that period, and I don't know what it is today, was that DHS was responsible for what we call the departmental costings, which was like staff, IT, postage people, but not the outlays, which were the social security programs, which were the responsibility of the Department of Social Services. I have reviewed my email, I have reviewed the papers, I have found no evidence that I saw the outlay costings.
Did you see a draft of the new policy proposal?
Not that I can find.
You didn't see the final new policy proposal?
Not that I have been able to find, and it may be the case, but I have found nothing yet so far.
And do you mean to convey by your response that you have no recollection of ever seeing the final result of this contentious program?
So it wasn't contentious back then? So, of course, I have now seen the new policy proposal because I went on to be the Secretary of the Department of Social Services. But at the time, in 2015, I did not see the new policy proposal, and my recollection is that we didn't receive the full Cabinet documents. We only received excerpts that were relevant to the Department of Human Services.
Did you attend a Cabinet subcommittee called the Expenditure Review Committee in the first half of 2015?
I can't recall. I did, at least on an occasion where Minister Payne and I talked about another program, but I can't recall whether I attended when this measure was discussed or not.
Do you recall attending with Minister Morrison, Minister Payne, Mr Pratt in the ERC?
I can't. So Minister Morrison and Mr Pratt may have been at the ERC that Minister Payne and I attended on another measure, but I can't recall. There were many such meetings.
Many such meetings in the Expenditure Review Committee?
Yes.
The Expenditure Review Committee considers new policy proposals and submissions supporting them? It
does.
And if you were present, it would be because you could speak to the new policy proposal then under consideration?
Yes.
And that would require you to have technical knowledge of what was involved in the proposal so you could answer questions about it?
Yes.
And it would require you to be fully briefed about the nature of the proposal.
Yes.
You wouldn't attend an expenditure review committee as a subcommittee of Cabinet without being fully briefed.
So secretaries were required to attend, and it was my practice to be as briefed as I could be in the time available to attend an ERC.
I suggest there are only 4 DHS policies in budget measures in the 2015-2016 budget, and there were about 40 DSS in the same budget.
So if we went to page, I think it's 41 to 43 of budget paper number 2, I've asked for someone to get those pages printed for me. It gives a list of all the expense measures for which DHS will be receiving funding, and that outlines a large number of programs across a broad range of portfolios where DHS would have been involved. But I don't know whether we've got it or not.
I've just been handed a copy of those documents. That's the Assistance to Council assisting. And the witness? I have one more copy that could be made available to the Commissioner, but I note that a question of parliamentary privilege might arise if it was to be tendered.
Thank you.
When you refer to a large number of proposals, you're talking about funding that DHS might receive.
Yes.
Right. What about savings that might be gathered from the measure?
Yes. Both of them are in there.
All of them?
Yes. So those pages would detail what funding human services would receive in order to deliver those programs, and what funding would be removed from DHS due to either a savings measure or a decision not to proceed with a previous measure. So if it's helpful, I could go to some examples of both of those.
No, I'm suggesting to you that the OCI proposal was of particular significance out of all of the proposals that were advanced in that budget round. That's what I'm suggesting.
So it is one of the larger ones, but there are others as well. So from a departmental expenditure perspective, on page 43, it talks about strengthening the integrity of welfare payments, the amount of money that was provided to DHS in order to implement that. But there were other measures such as the welfare payment infrastructure transformation, which was a larger amount in 15-16. There are other measures such as no jab, no pay, a broad range of measures in the growing jobs and small business, sometimes a delay in a measure such as increase on page 42 in the middle, increasing the age of eligibility for New Start allowance and sickness allowance. So this reflects the number of measures that we were to implement coming out of the 15-16 budget.
How is it that you can be involved in clearing costings for the OCI budget measure and not see a draft or final new policy proposal? How's it segmented like that in your office?
Well, it wasn't me not seeing it. I wasn't responsible for the costing of the administrative elements, and I should have asked for different pages here because I'm assuming the DSS side would have the amount out of the outlays that were identified in this measure, and so that would have been their responsibility, which is the $1 billion number, and the costings that I would have signed off on would have been these costings here, which reflected the departmental costs of actually running the program.
So is it your evidence that you cleared costings in a vacuum from the other side of the ledger, which was prepared by DSS?
I cleared the costings about what was required from the Department of Human Services, but the expenditure costings, the saves that were expected to be garnered from this measure, were cleared by DSS.
Assume that's the case. You're saying that you only looked at the part of the document which related to DHS expenditure, and not the rest of the document.
Well, I'm not sure I had it. And sometimes the Department of Human Services didn't receive the final copy of the MPP. It may be that it was somewhere else in the department, but I don't recall having the MPP. Portfolio budget statements usually came to me in a hard copy form, and the Cabinet Secretariat decided which ones we got. And sometimes we didn't get all of these measures. So if you look at the many measures we were implementing, I'm not sure we saw what was known as the outlay costs in Medicare for those ones. I didn't probably clear those costings. They'd have been cleared by the Secretary of Health.
Yes, I'm asking you about how you could prepare your costings in isolation from the whole proposal. How could you do that?
We would have understood what was required of DHS to do it, but
How would you understand that without any document?
There would have been discussions between the officers at the level about what was required for DHS to do. There was a funding model that DHS had for a number of programs. If customer numbers changed or something like that, that's how the costing was discovered, or the costing was prepared.
And you were comfortable preparing costings, which you cleared for an expenditure review committee on a new policy proposal without seeing the rest of the policy proposal?
We weren't always able to see that. We developed the costings on the best information we had, and we gave those to the agency who was taking them forward. So, for example, on this occasion, Human Services took forward the Welfare Payment Infrastructure Transformation, which was the IT system, because that was related just to Human Services. So I saw that new policy proposal and took that forward. The one on the NDIA full scheme ICT, I don't think we would have seen the full proposal for that. We would have only seen the part that we had the elements of.
How did you know how much money DHS required to implement the measure without seeing the proposed measure?
We would have had the information about what was asked of DHS to do it.
How?
It was worked out at officer level about what was required, and I think that was what was outlined in the secretary brief to me when a costing came through, what was being asked of DHS to do.
And you've not found that in respect of this measure?
I think we have found that. I think we found the secretary's brief. I think we talked about that last time I was here, but not the new policy proposal, not the final new policy proposal.
Or a draft of it?
I haven't found it.
Is that a convenient time?
Yes, 2:30.
All rise. The Commission stands adjourned until 2:30 p.m. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
That's why I need a junior. Ms Campbell, before the lunch break, I was suggesting that you really did understand the nature of the proposal that was to be implemented under the OCI program in order to do the costings for it.
The costings, so I cleared the costings, and the costings were developed by, they were cleared by the Deputy Secretary. I think there's evidence that the emails that were sent to me, and then there was a Secretary's brief which detailed to me what the costing was about. And so, yes, I understood that in that regard. But I don't think I asked for the legal advice at that time.
If Exhibit 1952 could be placed on the screen, CTH.3004.0001.4295. Ms Campbell, this is an email that you are referring to, I think, in your answer, when on the 9th of March 2015 you received a Secretary's brief for strengthening the integrity of welfare payments and a finance summary, which were the costings that had been cleared by Melissa, that's Melissa Golightly, and Emily, with ICT costs approved by Gary, and the note that the costings need to be sent to finance tonight if at all possible.
Yes, I received that email.
Yes. And these are the costings for the expenses to be incurred, that is the appropriations sought by DHS under the proposed budget measure.
Yes, the departmental costings.
Yes. Thank you. If we can go to the next exhibit, Exhibit 2024, CTH.3004.0001.4297. This was the attachment, that is the Secretary brief, which had been marked up in the process of the review by those referred to in the email. And if we go down to the date submitted to the funding type and pull that out, see that there'd been an update in the date from the 8th to 9th of March. The costings were for inclusion in the DSS portfolio budget submission. The costing title was 001944, the budget, what became the budget measure, and the business owners were all persons within the Department of Human Services.
That's what the document says, yes.
The total costs, that is appropriations sought, was at this stage $262.7 million.
That's what the document says.
And if we go over to the second page of the document, you can see at the top of the page, under the box, that's it. The costing deals only with the DHS costs of the proposal. The administered savings have been costed by DSS. That's right.
That's what it says, yes.
That was your understanding
That
when
is
you
my
reviewed the
understanding,
document.
and that's
yes.
what I've talked about.
If we go down to the individual elements of the package,
Just before my friend continues, I can provide a hard copy to the witness. It is quite hard to see with the colours.
thank you.
Thank you.
had the opportunity to read that?
I have had the opportunity to read that.
You can see that as at this date, 9 March 2015, the individual elements of the package very closely resembled, if not identically resembled, the proposal contained in the executive minute 12 February 2015 to Minister Morrison.
Yes.
You have an identical number of customers in respect of the clean-up of potential incorrect payments and the same financial years identified. You can see that.
Yes.
The discrepancies arise from PAYG file information obtained from the ATO. The proposal was to present it to the customer via their online account and require them to confirm the information is correct or provide updated information. Those are all similar, if not identical, features contained in the proposed proposal in the minute.
Yes.
What is different, though, about this costing feature is the next sentence, where it asserts this approach will not change how income is assessed or overpayments calculated. You see that?
I can see that sentence.
And so there had been a material change, hadn't there, Ms. Campbell, from the department's position in the executive minute, that it was a different proposal involving changes which required legislative and policy accommodation to an assertion that nothing had changed.
There is a change, yes.
And expressed that way, this proposal, that is, these individual elements of the package, suddenly didn't require legislative or policy change because there was nothing different.
That's what this document says.
Yes. Can you explain how you were involved in drafting the 12 February 2015 minute, which identified that it was a new policy, a new proposal or a new approach which required legislative and policy change, to the inclusion of this sentence, which asserted the contrary?
No, I can't explain that.
At all?
I can't recall. This was 7 years ago. And I cannot recall noting that difference 7 years ago in this document.
But it explains why there's no legislative change required to introduce the measure, doesn't it, based on that representation?
So your question is to me, did I decide that there was no legislative change?
No, my question to you is that sentence, which represents that the elements of the package do not change how income is assessed or overpayments are calculated, explains why there was no longer any need for legislative or policy change.
I think that is an interpretation of it. I'm not sure that I made that interpretation at that time, because I'm not sure whether legislation's dealt with in this minute. I was just looking for that.
It's a costing minute.
Yeah. And legislation was not generally dealt with in a costing minute.
That's right.
But so I think that is an interpretation of that, but I note that the words legislative change are not in that paragraph.
Nor is the suggestion that it's a new approach.
Those words are not in that paragraph either.
Nor is the reference to the shift in the onus in the paragraph.
Those words are not in that paragraph.
Nor is the reference to the primacy of PAYG data from the ATO in calculating debts.
Those words are not in that paragraph.
All of the features of the new approach, according to the February 2015 minute, have been removed and replaced with a single sentence that asserts the contrary by someone.
So that's in a costing document, which was generally a summary of it, but I don't think, so this document was seeking my agreement to proposals going to the Department of Finance on spending, on appropriations. I don't think this was a definitive document on whether or not legislation was required.
Certainly. But here there was an opportunity to accurately describe the individual elements of the package in the costing process in anticipation of a new policy proposal, and what was represented was very different to the 12 February 2015 minute. You would agree with that?
I agree with that.
That's been the department's line since the budget measure was announced in 2015, hasn't it, Ms Campbell? That the approach under the OCI program did not change how income was assessed or overpayments were calculated.
That proposition was put, and we discussed earlier that that was probably not accurate.
I appreciate that it's not accurate, but the department adopted at this point, 9 March 2015, a position that the new online program, which became Robodebt, did not change how income was assessed or overpayments were calculated. And it has maintained that position ever since.
No, that's not correct. The department has, so I am not of the department at the moment, so let me be very clear. Your comment was ever since, so I have not been involved in the portfolio of the Department of Social Services since the 20th of July 2021, to be perfectly accurate. The department changed that view in 2019 with the arrival of the Solicitors General's advice and comments made by ministers at that time. So in leading up from when the annual report, and we talked about that earlier this morning, but there has been changes since, so I don't think it's accurate to say that the department has held that view ever since.
All right. The department held that view while you were the secretary in December 2015.
It did.
In January 2016.
January 16.
Sorry, 17.
January 17, yes.
It held that view in response to the Ombudsman's inquiry.
Yes.
It held that view in response to representations by peak bodies such as ACOS and the CPSU.
Yes.
It wrote draft speaking points for ministers which expressed that view and were stated publicly by those ministers.
That was the view held by the department at that time.
And it was held ever since the 9th of March 2015 until you left the department in 2017.
It's not true. It was held that view until the Solicitors General advice was received in 2019.
Yes. Certainly while you were Secretary of the Department of Human Services, this was the position adopted by Human Services publicly in respect of whether the program changed the calculation of income and the calculation of debts.
That was the position held at that time, yes.
You didn't have any legal advice to permit the expression of this view, did you?
At which point in time?
9 March 2015.
So I'm not sure when I was reading a costing minute that went to legal advice. When I was reading a costing minute, I was generally looking for numbers. I wasn't looking for legal advice on a matter. So when clearing a costing, I was generally looking at numbers.
You had the opportunity to correct any misrepresentation about the changes in the program when this came to you for your clearance.
Yes.
You didn't change anything?
So it says to me, recommendation that you agree to the following costing. I suspect I agreed to the following costing. I don't know that, unless there is some evidence which I haven't seen, that I went through every line of this. I was asked to agree the costing and I agreed the costing. Could I have read every line and worked out whether or not this was different to something that I had seen previously? Yes. But my mind at that point would have been agreeing the costing.
Are you explaining why you didn't change the representation contained in this document to be sent to the Department of Finance?
This document was a costing document. It wasn't meant to be a legal definition of the program document.
Surely you understood, though, that in the development of a new policy proposal, your department was involved in describing the implementation of the measure in order for it to be costed?
So I would have cleared many costings.
I'm not asking you that.
And
I'm asking
so-
you about your department's responsibility.
So the department shared a responsibility with the Department of Social Services to describe this measure. We did not. The definition that was provided here was probably provided, I assume, to the Department of Finance. I did not ask for legal advice on this, and I did not identify that there was an issue with this at the time.
Well, you can't recall if you read it or not, so
I suspect I read it because, and I have seen an email response to this, which I said, I think, and I don't have the document here, that I was okay with this going to finance because I wasn't in the office at the time. I think it was late at night. So the recommendation on this document was to agree the costing. I accept that in the document somewhere there's material which was different to what we had put up before, and that I didn't challenge why it was different to put up before. But when I was agreeing this document, I was turning my mind to the costing. I wasn't turning my mind to the legality of the measure.
now, you would agree with me that the same concession you made about the annual report misrepresenting the position applies to this document?
At this time or now? So now I look back at it and say that yes, there could have more detail could have been put in this document, but it depends on the purpose of this document. The purpose of this document was to get me to agree the costing. Misrepresentation or incorrect? So it would have been a more fulsome description would have been better in this document.
Positively represented that there was no change to the way income was assessed or differences were calculated when that was not in fact the truth of the proposal.
So this document came to me for costing purposes. I don't think it was, I'm not sure where else it went. So misrepresenting to me, yes, it was a misrepresentation to me. This is not me writing this document. This is me receiving this document and agreeing to the costing. So it would have been better if it was accurate and more fulsome, but I'm not sure I would have identified that in the quick turnaround in agreeing the costing.
Is that because you expected the terms of the proposal in the way it was expressed?
I don't think I turned my mind to... You're talking about the difference between what had gone to Mr Morrison in February versus what was here in March. I expected it to be whatever had been agreed with DHS and DSS, and I didn't have the detail. I don't think I had the detail of what had been agreed with DHS and DSS.
Given that you expected it to be what was agreed, when you read it, you would have observed that it was very different to your understanding.
I don't think I did observe that it was very different.
How? Could you have
Because
missed
I
that
was-
fact?
Because I was clearing hundreds of costings, and I don't think every time I cleared a costing, I asked for the complete correspondence that went with that costing.
You didn't have to ask for the complete correspondence. It was summarised in the document before you.
And I didn't notice that it was significantly different to what we had proposed.
Or different at all, you say?
I don't think I said that.
Sorry?
I don't think I said that.
Well, what difference did you note? If it
didn't
wasn't
note-
significant?
I didn't note any difference. That was the evidence I gave, that I did not note any difference. And when I was clearing a costing, I was not clearing the legal advice that went with the new policy proposal.
This explains why no legal advice was sought by you, doesn't it? Because there
No.
was no need for legal advice on the misrepresented position.
So, a new policy proposal would have gone from in the portfolio budget submission. And that format would have included a table at the back of the new policy proposal, which would have dealt with a number of issues such as regulatory impact statements, constitutional validity, whether legislation was required, whether a risk assessment was done. This is not the document in front of me that included those materials.
I wasn't suggesting it did. What I'm suggesting to you is that you were content for a misrepresented position about the nature of the program to be forwarded to the Department of Finance.
So I did not identify that there was a misrepresented position here,
How can you be so confident about that given the passage of time?
because I was asked to agree a number. So I was asked to agree strengthening the following costing. So that was, the costings are primarily the component with the numbers in them. So it's the detail of the numbers. The words were for me, is my understanding, so that I understood what was being costed. So the costing information commencing on at paragraph, after paragraph 9, had all the details of the numbers in them. But I did not necessarily consider the words were what were being agreed.
Would Exhibit 1966 be brought up, CTH.2007.0002.6796? This was an email from you to Melissa Golightly, Thursday 22 Jan 2015, 6:40 p.m, sent from your phone. Does that suggest to you you were out of the office?
I don't know.
Or wouldn't you type on your computer if you were in the office?
There were a number of DHS offices, so I could have been in one of the other offices around Canberra. I could have been in a DHS office somewhere. There were several hundred, so I don't know whether I was out of the office or not.
No, you could have been at home.
Could have been at home,
All right.
been on leave.
22 January 15, you had met Minister Payne on the 20th of January 2015 to discuss the draft to be sent to Mr Morrison. You recall that?
That's in my statement, yes.
And 2 days later, Melissa Golightly emails you a revised draft compliance brief and updated attachments, and she added a particular paragraph re your meeting with Commissioner Colvin. You see that?
Yes.
If we could go to the top half of the email commencing Melissa and Mark and pull it out down to thanks. You thought that this version of the brief looked more punchy. You thought it was worth mentioning that you're a member of HOCLEA. What's that?
Head of Commonwealth Law Enforcement Agencies.
And as a result of your suggestion, that was included in the 12 February 2015 minute.
That's my understanding, yes.
Go on to say, I think there's a typo in one of the attachments around the ATO data. The years we are considering 2103 instead of 2013, brackets. Yes, detail obsessed, I know, sorry. You see that?
I do.
You were obsessed with the detail of all the documents you were asked to sign off on, weren't you?
No, not all of the documents. So I think to make the assumption that I picked up a typo in a brief to say that I went through every line of every document in that job is an assumption that can't be made.
Well, it was clearly a highlighted passage in blue that had been updated for your recommendation and left in track changes for your approval. We could go back to Exhibit 2024.
So I don't think that there is anything about legislation in there. And it's 7 years, I can't recall.
That's the point. There is nothing about legislative change or policy change in this document. And you say that escaped your notice, having settled a minute only the month before, which said it was new and required those features.
But this document wasn't the mechanism to communicate to ministers the nature of the new policy proposal.
Why would you be prepared to send inconsistent messaging amongst departments about the nature of the program in anticipation of a new policy proposal?
So, because DSS was doing half of the costings and because DHS was doing half of the costings, Department of Finance would have received costings from both of us.
Well, you must then accept that whoever drafted that paragraph inserted a misrepresentation according to the 12 February 2015 minute about the nature of the program.
So I don't know what discussions had been held with DSS between the time that paragraph was drafted and the document from February. So it is, I note, not accurate, but I don't want to say it was a misrepresentation because I don't know what discussions occurred between the person who, or the people who drafted this and DSS between that time.
Well, how can you concede that the representation in the annual report to the same effect is a misrepresentation as compared to what the program was, if you can't concede this?
Because I thought you had asked me about the annual report. That was I had signed off on that, and so therefore you were asking, did I think I had misrepresented? And I said, yes, this is not a document that was drafted by me, this was a document sent to me. And I don't want to make assertions about the authors of this document. I think that would be better asked of them.
Exhibit 1853 could be pulled up. And just the top part of the email pulled out, please. This is your response to the request which enclosed the previous document. Happy for these to go to Finance to get them started. Melissa, have we engaged with both AUSTRAC and CDPP? Do they need more money? Kathryn, sent from your iPad. That's your email?
Yes?
It indicates you are happy with the document to go to Finance.
Is this the same document?
If we could just go,
Yep, just checking.
right?
Yep, because I know one was from the iPhone, the other was from the iPad. Yep.
Right. You had the opportunity to correct a misstatement, to put it neutrally, about the nature of the program.
This was not, the nature of the program was not my focus at this time. My focus was the costing.
You had the opportunity to correct the misstatement about the nature of the program.
I could have redrafted the brief. I don't recall. I don't recall reading that part of it. My focus at that stage was on the costing.
You could have deleted the sentence which was inaccurate according to your understanding of the advice to the minister.
So my understanding, I could have, but I did not notice.
You could have sought clarification on why the position had changed.
I could have, but I did not notice.
Exhibit 1948, CTH.3004.0001.4626. And if we could call out paragraph 1 at the bottom of the next page, please. This was the document attached to your email in final version, which did not make any change to that critical paragraph. You agree?
There is no change to that paragraph.
Thank you. We could go to Exhibit 1953, please. CTH.2004.0002.8404. Sorry, I've given the wrong number there, cth.2004.0002.8404. If we go to the bottom half of the page first, and ask that that be called out. On the 10th of April 2015, the Acting Chief Financial Officer in your department sent you this email, which attached a draft letter for your consideration and feedback in response to the ERC decision on the Strengthening the Integrity of Outlays NPP. You can see that?
I can see that.
That is, in simple terms, at some point between 9 March 2015 and 10 April 2015, the ERC, that's the Expenditure Review Subcommittee of Cabinet, had made a decision on the Strengthening the Integrity of Outlays new policy proposal.
Yes.
Aspects of the appropriations under that proposal remained unresolved despite the decision in the ERC.
That's what it appears to be, yes.
And the letter was a draft to the Finance Minister regarding the Strengthening the Integrities of Outlays. That is the new policy proposal.
I can't recall the attached letter. Is that in my
Sorry,
file?
yes, it's
Sorry?
just there in the title. You'll see from, sent to, CC and subject.
Yes, I can see that the email concerns a letter. I thought you were asking me about the actual letter.
Well, I'm suggesting that what is referred to as the attached draft letter was a draft letter to the Finance Minister from Mr Morrison.
So to be clear, I'd just like to clarify what was attached
Certainly.
to that letter, if someone has that document.
You may be able to be shown a hard copy. There is a claim over it. Unless you have a copy in your folder.
I don't think so.
Right.
Oh, wait a second. 9th April.
I can give up my copy. I've got it. Is it? Oh.
Yes, the attached letter is a draft letter from Mr Morrison to the Finance Minister.
And it's in respect of the new policy proposal, which had been the subject of the ERC decision.
That's correct.
Yes, thank you. If that document can be returned. If we can go to the top part of Exhibit 1953. No, that's an earlier exhibit. This is cth.2004.0002.8404. I think I've been describing it as Exhibit 1953. It's 1963. I think that's the confusion. My apologies.
I just confirm, just so that there is clarity on the record, the document that I provided to the witness was the one ending 8404 with the attachment 8405. That's correct?
Correct. Yes. 8405 is the subject of a claim, I understand. Your executive officer communicated on your behalf to the Acting Chief Financial Officer that you were okay for the letter to be discussed with the Department of Finance.
That's what the email says, yes.
And that reflects a general practice of yours that you like to be briefed in hard copy.
It depends. I think this was sent to Secretary's office, so I generally tried to do my own emails that were sent to kathryn.campbell@humanservices.gov.au. The ones that were sent to Secretary's office were managed by my executive officer and my EA in order to keep track of documents.
And you suggested that Ms Golightly and Mr Withnall should go to those meetings,
That's what the email says, yes.
and it reflects what you suggested.
I can't recall. I don't think I received this as part of documents because it didn't go to my email, so it went to the Secretary's office. So I haven't been able to get all the documents that went to Secretary's office.
That was the 10th of April. If we I might just have a moment. Exhibit 1240 CTH.2007.0002.8121. Thank you. Again, there are two emails on this page. There is an email to you at 8:15 p.m, 23 April 2015 in the second half of the page. If that could be called out, please. As you indicated, there were aspects of the costings which remain unresolved after the ERC decision, and the options that had been discussed in detail between you and Ms Golightly and generally with the Department of Finance were what were attached to this email.
They were.
Now, in view of the earlier ERC decision, which had considered a new policy proposal, do you think it is realistic that despite the ongoing review of the costings between ministers and the Department of Human Services and the Department of Finance, that you did not see the final new policy proposal?
So the matters, my recollection is that the matters that were under discussion did not relate to the online compliance initiative, did not relate to the pay-as-you-go element of strengthening the integrity of the welfare system. My recollection is that they relate to proposals which did not proceed. And I'm not sure whether that's what's covered by the PII claim. So there were a number of measures in this pack that did not proceed.
Sorry, I've got the documents out of order. I might deal with the lower email by itself. I could have Exhibit 1945, CTH.3004.0001.4625. Actually, if that could not be brought up, can you just check and redact it as well? I think there needs to be a minor redaction. I'm told about 30 seconds, Commissioner. which is very efficient. In the meantime, perhaps, Ms Campbell, if you could have a look at the document. Yes, if that could be returned. I think we now have the redacted version on the screen. Thank you. This is the standalone email to you from National Manager, Finance Management Branch. Thursday, 23 April 2015, 8:15 p.m. Hi, Kathryn, Melissa. Please find attached a copy of the costings brief for the 2 revised options for the strengthening the integrity of the welfare system brief. There's a reference to the options having been discussed in detail, and attached also is the original brief for the proposal that was included, and there is a reference to the secretary brief 001944. You can see that?
I can see that.
The attachments, if we can go to the header, are the secretary brief 001944, which is the strengthening the integrity of welfare payments doc. The secretary brief 001944 revised 002255 final, and then 2 other documents which appear to be Excel spreadsheets, option 1 and option 2. Do you see that?
I see that.
Before I get into the detail of those documents, if I could have Exhibit 1961 placed on the screen, CTH.2004.0002.9818. If we could just go to the bottom of the page and call out the email from Ms. Armour. Now, you're not included in this email, but it's the following morning. Both have cleared. Secretary agreed to only send option 2. Do you see that?
I see that.
Yes. All right. And again, if we go to the top of the email, we can see that that's forwarded to Mark Withmull, and then from Mark to Scott Britton from Whitney Sparks, with the same attachments as were attached to the email to you.
I see that.
Thank you. And again, if we just complete the sequence, having locked in both ends of it, and go back to Exhibit 1240, you'll see that after receiving the email from Ms. Armour at 8:15 on the Thursday night, you responded at about 9:09. I'm happy for this to go to, if Melissa is okay for it to go, we will need Megan to engage with her counterparts. Melissa, can you let me know if you want me to contact Megan? I'll ring Finn tomorrow to alert him to the issue. You can see that?
I can see that.
Right. So you receive the attachments to clear the costs, but what is also included is Secretary's brief 001944 for strengthening the integrity of welfare payments, which you understood was relevant to the department's position in the new policy proposal to be considered by Cabinet.
Can I just clarify, was that the brief you showed before, 1944? I've just lost track of the documents.
Yes.
Yep, okay, thank you.
And so, if we then go through the attachments, Exhibit 1948, CTH.3004.0001.4626. And if we go over to the second page and pull out paragraph 1 at the bottom, you can see that this reproduces the Secretary's brief in the same words that were forwarded by you to the Department of Finance on 9 March 2015.
I don't think I forwarded anything to the Department of Finance.
Sorry,
think I
that you
said
cleared to be forwarded to the Department of Finance.
but I didn't forward it to the
You
Department.
are very precise and correct. Now, given that you were reminded in this attachment about the elements of the package, including the assertion that the approach will not change how income is assessed or overpayments are calculated, were you concerned that the position may have been, that misrepresentation may have made its way into the Cabinet?
No, I didn't. I had not identified there was an issue.
You spent considerable time with Ms Golightly preparing the 12 February 2015 minute. There was a draft from the 15th of January that was sent to Ms Payne. You met with Ms Payne on the 20th of January. You received a draft back on the 22nd of January, the one that you thought was punchy. There was a series of drafts which led ultimately to the formulation of the minute on the 12th of February, and in all of those it was identified that there were new aspects to this proposal. You would agree with that?
I agree that that was the case, and when you said that I had spent considerable time with Ms Golightly, I suspect I spent considerable time with a range of other Deputy Secretaries when I reviewed the budget papers as well.
This was a development of a proposal in conjunction with your own minister or the senior minister in the department. Your minister had made significant, or rather detailed, changes to it which had to be incorporated back in. There was a consultation process which spanned a number of weeks. And at each stage of that process, you satisfied yourself that what was contained in that proposal was an accurate state of affairs.
I cleared the costing, cleared the amount of the money. I'm
talking about the executive minute.
Executive minute. Okay, we're back to, executive minute, yep.
Okay. And you're saying from thereafter you didn't notice that the language about how the policy, or rather the program was described, had significantly changed to assert something inconsistent with the minute that you were involved in developing for weeks?
No, because this was one of the 58 measures that were finally agreed in the budget, which DHS was involved in, and I expect there were many more measures which were not finally agreed. So I am concerned, Council, that you indicate that this is the only thing we were doing at the time, and so therefore I should have, and I wish I had, picked up that there were changes. But there were many such proposals at that time, and I necessarily relied on others to run some of these processes.
I think I asked you this morning whether there was anything else that involved the sheer numbers of social security recipients and imposing obligations on them in a new way, because this contemplates 587,000 customers. Did you find anything comparable?
So there were a number of new policy proposals in that budget that had large numbers of people impacted.
500,000?
Social Security assets test, the rebalance of the assets test threshold and taper rate. It achieved savings of 2.4 billion. I think it was about 500,000. These were pensioners for whom asset test changes were coming into place. That was one such measure. I don't have the customer numbers on some of the other measures, but the no jab, no pay, which had quite a significant impact on all recipients of family tax benefit. That was another measure in this budget. It had a savings of 508 million, but it had quite far-reaching impacts because parents would have to ensure that their children were vaccinated and those vaccinations were recorded in order to continue to receive family tax benefit. The measure removing the double dipping from parental leave pay, it had significant consequences on a large number of people, and it was proposed to achieve savings of 967 million over 4 years. So,
Yeah,
yes,
this was a measure which actually made demands of people to do something in a way they'd never had to do before.
so I've gone back and looked at how many compliance measures in the past had been implemented, and we had probably implemented a compliance measure every budget, most budgets, most MyEFOs. And I don't know that I focused as keenly on this one as I did on some of those other measures that I've just outlined. They had large numbers of recipients and Australian citizens impacted. So this was not the only big measure in that budget. There were other measures as well. That doesn't excuse the fact that there's things that we've already agreed would have been better to have a look at. But I suppose the context is that it wasn't the only large measure.
No, but it was a very large number of people on whom you're going to, of whom you're going to ask provision of information going back up to 5 years. Would you not be concerned to make sure that what you were asking was fair and reasonable, let alone legal?
So meant we had considered whether this was reasonable. Once the process was rolled out, I wasn't satisfied that we had given people, hadn't made it as easy as possible for people to comply with
Right,
this.
we're talking 2015 at the moment, though.
Yeah. So 2015, this was advice provided. The material that's been before me, the costings which are prepared by the CFO area. When I'm looking at a costing from the CFO, I'm not always looking for legal advice in that.
No, but you know that this program is going to be put in place. Would you not want to know about how it's going to work to some extent, to some level of detail, so that you can be sure that it's a fair thing to do to this very large client base?
So I thought I did understand that at the time.
You'd understand the program?
I understood the program when we briefed Minister Morrison in February, what was required. I didn't then work out whether or not the legislation was put in place before it was rolled out, and it wasn't. But I had a number of deputies who were working through this as well, and having looked at that budget paper, there were a number of other very big measures with a number of recipients that I was probably focused on as well.
All right, thank you.
Well, what you knew in the start of 2017, when you came back from your holidays early, I think, was that the program had been implemented as you described it would be in the 12 February 2015 minute.
Yes.
Which you understood to involve significant changes to the way income was calculated and debts were calculated compared to the manual compliance programs of previous years.
So in 2017, I'm not sure I went back and reviewed the 2015 document. So I don't think I did a comparison between what we said to pursue versus what we were looking at in 2017. So in 2017, we looked at what we had to determine how we could improve or work out what would be necessary to improve this process. And I think in 2017, I was focused on ensuring that recipients were able to access the system. And then we saw the Ombudsman report and the advice from DSS about the legal advice at that point.
So between the 12 February 2015 minute, consideration of the new policy proposal, after the 12 February 2015 minute, and for the period which followed up 9 March, consideration of the new policy proposal by the ERC, these costings on 10 April, you really were looking elsewhere other than this aspect of the detail of these documents because you were very busy.
I was very busy and I wasn't looking in a costing process. I was really looking at the money. I wasn't looking at the legal requirements. Because this is the CFO sending this to me. So CFOs, I'm usually focused on money when I'm talking to CFOs.
That's what this was, this measure. It was about the money.
What was your question, sorry?
This measure was all about getting money.
This measure was about ensuring the integrity of outlays as well as providing budget offsets.
Budget offsets in the order of $1.2 billion.
That's right. Over 4 years.
Yes. And in order to do that, you were seeking on behalf of your department approximately $250 million in appropriations over that period.
So I think the 250 million relates to the entire strengthening welfare outlays, of which online compliance initiative was one element, and I think that was the initial proposal. There were many elements of this proposal, some of which were not agreed. So I can go to what the amount was in the end, but I don't think it was 260 million because I think there are a number of elements, including another measure, which was not involved in the online compliance measure.
Not sure what exhibit we had on the screen before it went red again. It could be brought back up. Yes, and if we could go to the first page, please. I think that's the 9 March 2015 one. After 23 April 2015, Exhibit 1949, CTH.3004.0001.4634, please. The total impact in the middle of the page there on costing 002255, that's option 2, the preferred option, is approximately $247 million.
Sorry, I didn't understand the question.
Did you see that?
I can see that.
Yes, right. So if we then go to the second page, If option 1 and option 2 could be pulled out, please. Thank you. Option 2 was the recommended one in this document that you're asked to clear. And it contained proposals that reduced effectively the amount sought by way of appropriations to implement the OCI measure.
That's one element. The other element relates to case cleansing.
Yes. By far the larger measure was the PAYG component in terms of appropriations.
I don't, where's the case? I'm just trying to find where the case cleansing cost is. Anyway, it didn't proceed.
Case cleansing didn't proceed.
That's my understanding, it didn't proceed.
So if we go to the last page, ending 4640, please. You can see a table setting out option 2. And this is where that figure of approximately 247 million is calculated.
Yes.
All right. It's over the life of the measure for the measure.
Yes.
It doesn't appear to involve the case cleansing component.
I think option 2 did have case cleansing in it. From the previous page it showed me, I thought option 1, I'm sorry, I may be mistaken. If I can just go back and see that last page.
Yes, if we could go to the page ending 4635 and call out option 2, please.
Option 2 had case cleansing but rephased, removing all activity in 15-16 and then putting it in the out use. So I suspect that number did have case cleansing in it.
Doesn't appear as a separate item in the strengthening the integrity of welfare payments measures appropriation on the last page.
No, it doesn't appear, but it would have had a separate costing because my recollection is case cleansing got removed at some point.
You go to Exhibit 2026, CTH.3004.0001.4643. Ms Campbell, you'll recall that there were 2 Excel spreadsheets attached to the original email, and we have gone through 2 of the documents. This is the 3rd, and you can see that this is the 002255, strengthening the integrity of welfare payments, option E as it's described here.
Yeah.
Thank you. There might be a hard copy of the document, it's in A3. You just have a quick look through that document, Ms Campbell, you'll recognise it as the spreadsheet of all the various calculations which underpin the detail sought by way of appropriations of approximately 247 million over the life of the scheme.
It's not clear to me whether I would have opened this attachment. They were attached and they were sent to me, and it was a very good discipline, but I would only delve into them as required. So it's not, I can't recall whether I opened this attachment or not.
The attachment is, as I described it, the various calculations contained in detail which underpin the appropriations sought under the budget measure.
For the Department of Human Services.
Yes.
Yes.
We go to the second page. You can see the heading financial summary, if that could be called out, down to total change in resourcing. And you can see that figure again, 246,662,000 over the life of the scheme, with the largest part of the appropriation being allocated for the 2015-2016 financial year.
So the hard copy I have has got 256,832.
You might have option one
I might have the wrong option.
rather than option two, yes. But in any event, you can see,
Anyway, this is what they look like.
yes. This was the lesser of the two costing options,
Yes.
yes. And the recommendation was that the lesser of the two costing options, by about 10 million over the life of the scheme, be sent to finance.
That's what the document says. I
Yes.
can't recall.
All right. Can I take you to the page entitled Volumes?
Is there a page number on there?
No. The fourth from the back, I think. The next page. There we are. It's very small and it's very hard to read, but perhaps if at this, thank you, it captures it. We can see the various columns are data entry, that is function, brief description. We're concerned here with the costing of data entry in relation to the measure. There are various categories of data entry that would be undertaken by staff in respect of this scheme, but if I can take you down to the row marked appeals, there was a figure given of 2.5% of intervention volume will appeal. You can see that.
I can see that.
Is it the case that someone in the department, not you probably, had done some predictive analysis involving the number of people who might appeal debts raised by the OCI scheme, and that's what that measure reflects in the attempt to quantify the amount of data entry or time spent in terms of average staffing levels for the implementation of the measure?
It would appear that would be the case.
You don't know where the figure of 2.5% comes from?
No,
You don't know whether it's higher than the average number of appeals
I don't know.
or the same? Go to the next page, which is the funding model. Sorry, yes, thank you. The columns at the top are the activity, and that's a reference to income support payments. Unit price, a volume profile, and then a volume, a percent and a dollar figure allocated for each of the financial years. Does this reflect the other side of the equation, that is the offsets that would be achieved by the program according to predicted amounts of debts which might be calculated and their volume?
So it is 5 years since I've got into a Department of Human Services costing, so I can't recall, but it may be that these were the number of people who were expected to come off payment, and therefore the department would not receive the unit price for the ongoing management of these recipients. So the thing that leads me to believe that is the costs for the disability support pension, which I thought, and the age pension were about $122 per year we got per age pensioner. So this table, and I can't remember this table until I'm looking at it now.
In terms of funding or appropriations for implementing the aged care pension program?
Age pension program. So for every,
Age pension.
the funding model would give us an amount per annum to administer those people. So, for example, New Start, you got $918 because New Start recipients needed to be contacted, to be engaged, and therefore there was a lot of work with a New Start allowee versus an age pensioner on full rate was pretty low because they went on to payment and not much happened to them. So I suspect it could be that this was the expected changes to the customer recipient profile.
Which had an impact on funding for average staffing levels?
Yes, but not very much. It was only 7 million.
Thank you.
And there was lots of ons and offs. So Human Services was funded on the expected number of recipients, so it was very sensitive, as you can see, to New Start. So if unemployment rose, Human Services got more money in order to service the New Start client base.
Yes. Could now go to Exhibit 1241 2006.001.0356. Again, Ms Armour sends you an email Friday 1 May 2015, getting much further from the Cabinet decision and closer to the budget. And the attachment is the Secretary brief, strengthening the integrity of welfare payments, 002359, final agreed between MOs, that's Ministers' offices.
Yes.
And that's borne out by the content of the email, which indicates that there was agreement reached between the Ministers' offices that afternoon in respect of the revised costing. And the Ministers were, as you understood, Minister Morrison and Minister Cormann.
Their offices.
Yes.
Yes, I'm not sure whether the Minister for Human Services office was involved. I'm not sure.
Right. That is, it took until the 1st of May for the leftover question of costings to be agreed following Cabinet decision, whenever that was.
That wasn't unusual.
And you can see the costing is the next document, CTH.2005.0001.0357. We could just go to the final page. Thank you. Sorry, page 0359, table at the top. Thank you. You can see the original costing, approximately 247 million over the life of the scheme, removal of the case cleansing component, the reduced task force average staffing levels, and a revised costing, which is this document, in the total of 172,371,000.
That's what the document says, yep.
And from your reading of the agreed costings, that was the appropriations measure eventually agreed for the department to implement what became OCI.
That was, OCI was one element. So for example, this talks about the task force, which was a different part of that measure. And so the adjustments were about task force and the fact that we didn't proceed with case cleansing.
Yes. Should
So-
say, over the life of the scheme includes all components of what is described as the Robodebt scheme in the letters paid.
No, it includes all elements of the strengthening the integrity of welfare payments, which had more than just the online compliance initiative. Because there was a task force.
Yes.
It was also, which was not part of the, what is termed the Robodebt scheme. Just trying to. So there was, you may recall in
I'm not
the,
saying it was exclusively the Robodebt scheme, but I'm saying this appropriation included all iterations of what was the Robodebt scheme.
when you say all iterations, do you mean?
Annual compliance intervention 2015,
Yes,
2016,
yes,
OCI 2016. Thank you. And onwards.
Onwards until there was a new measure, and then that would have changed it.
Yes. All right. Thank you. If Exhibit 2022 could be produced, this is the redacted new policy proposal. Appreciate you say you haven't seen it, or you can't recall seeing it, or you haven't seen any evidence that you've seen it. But I'll take you to page PMC.001.002.017.
Can I just clarify that statement you've just made?
Yes.
I didn't see it in 2015. I subsequently saw this when I was the Secretary of the Department of Social Services.
So if we go to, they're all numbered the same. Page 22 of 364.
I'm just wondering, Councillor Sting, whether there's a hard copy of this bundle if you're taking her through this additional tranche. Otherwise, I could volunteer my sole copy, hard copy.
And I've just realised that this is the entire portfolio budget submission for DSS in 2015. So what I just said, I saw the new policy proposal for the strengthening the welfare, I don't know that I would have ever seen the entire portfolio budget statement for DSS in 2015. I wouldn't have gone back to look at it when I was the secretary.
Of DSS.
A former PBS, portfolio budget submission, no, because I would have had the one I was dealing with at the time and the next one. But I did look at the new policy proposal for what's termed Robodebt because it became topical. But I don't think I would have gone back and looked at some PBS for every other measure because there's 364 pages.
But this is just a single attachment I think you're being taken to,
Okay.
which I think is the new policy proposal, isn't it?
It is. The bottom half of the page, this approach would be used through to the bottom of the page, if that could be called out. That all looks very familiar, doesn't it, Ms. Campbell?
I don't recall the regulatory issue being discussed earlier, but I may have missed that.
Could I provide my copy to the witness, since there's no other copy apparently in the room?
Thank you.
Ms. Campbell, the description here is perhaps a slight blend of the two previous documents. In the second dot point, it refers to a new approach but says it won't change how income is assessed or overpayments are calculated. Otherwise, the information is essentially the same.
In this document that
Yes.
that I saw again, yes, this information is the same.
And again, the representation that there would be no change to how income is assessed or overpayments are calculated contained in this document was inconsistent with your understanding of the proposal as it was described in the 12 February 2015 executive minute.
So when I looked at this, whenever I saw this in 2017, and the minute, I probably didn't think back to the minute in 2015 to do the comparison, but I don't recall seeing this document in 2015.
Having done the comparison today, you'd agree with me that the representation that there is no change to how income is assessed or overpayments are calculated adopts a different position to that advanced in the 12 February 2015 minute.
Yes.
And it adopts a position similar, if not identical, to the position contained in the 9 March 2015 costings, which you say you didn't read.
Which I did not turn my mind to, a costing that was, I was looking at it from a financial perspective, I wasn't looking at it from a legal perspective.
And it contains effectively the same language as the costing document, That is the Secretary's briefing, which was agreed by the ministers up to the 1st of March, 1st of May.
So my understanding is the Secretary's briefing did not go to ministers on the 1st of May, and the thing that was agreed was in ministers' offices, not by ministers. I note here that there's a discussion about regulatory burden for small business, and I don't recall that being in the document, the costing, which I probably didn't read more fully, back in April. So if I can just find what that said back in April. So I'm also looking at the costing Secretary's document, Secretary's briefing for the costing that was finally cleared, and that paragraph which you refer to is not in that Secretary's briefing. But if I can just find or if we could bring up the Secretary's briefing paragraph, I do think there are changes from that paragraph to what was here in the new policy proposal.
You'll agree with me that the scheme targets the same numbers of individuals over the same financial years?
Yes.
All right. And it does it by the clean-up of potential incorrect payments?
Yes.
And it does it based on discrepancies based on the analysis of PAYG information obtained from the ATO
Yes.
through presentation of an online account
Yes.
which required a customer to confirm information or provide updated information,
Yes.
shifted the obligation to the customer to ensure their record is correct.
That's correct.
All of those are features contained in the 12 February 2015 minute.
That's right. And there's that additional sentence which removes a significant regulatory burden for small business that is required under the current approach. Now, I don't recall that half of the sentence being in any briefing that you have showed me today.
Yes.
So I'm just pointing that out, that is an element that wasn't in previous briefing.
All right. But it doesn't change the nature of the program, does it?
But it does change the suggestion that the paragraph that was given to me was automatically put in this briefing. It indicates to me that someone else has been involved in this briefing as well.
Doesn't change the concept of averaging.
Doesn't change the concept of averaging.
Doesn't change the transfer of the onus to the recipient.
No.
Doesn't change the primacy of evidence from PAYG data.
No.
Doesn't indicate that averaging will take place if no one responds.
No, but it does change the assertion that the words in the Secretary's brief were the same words used in the new policy proposal.
So you can't explain, I take it, because you didn't pay any attention to the language in the document 9 March 2015, how this representation that the program would not change how income is assessed or overpayments are calculated ended up being the DSS position in the Expenditure Review Committee.
I don't know who the author of this document was. I don't believe it was me. I don't believe I saw this at the time. And so I can't explain this document because I have found no evidence that I ever saw this document at that time in 2015.
Surely, as Secretary, you would look at each new policy proposal that your department was involved in for which it sought appropriations under the annual budget.
These material did not always come to the Secretary of the Department of Human Services. This document on the screen is the portfolio budget submission for the Department of Social Services, for the Social Services portfolio. We would get extracts of those documents because we would get extracts because some of these proposals in their portfolio budget submission would not involve DHS. We would get extracts from theirs. Sometimes we would get extracts from theirs. Sometimes we would get extracts from health, education, infrastructure, if there was something that was involved. But I do not recall seeing this. I do not recall clearing it, and I haven't been able to find any evidence where I saw that.
It's clear, though, to you that someone in your department had to explain what the money was for.
Money.
The appropriations, the approximately 250 million that was sought originally.
So I expect this new policy proposal included whatever the 250 was, as well as the impact on what's known as the administered expenses, which was the billion-dollar number, 1.2 billion. And so I do expect that the Department of Human Services work with the Department of Social Services to develop this new policy proposal. But I haven't had access to the documents that were not sent to me. So I am unable to comment on who in the Department of Human Services saw and contributed to this document.
Because you say you never saw what your department prepared in respect of the budget measure, you can't help the Commission in any way.
I don't think I have said in any way. In fact, I think I have tried very hard to help the Commission in many ways.
Let me rephrase. You can't help the Commission with how this position came to be represented despite the position that you were content with in the 12 February 2015 minute.
No, I can't.
No. Someone else must have done it without your knowledge at a point in time that you can't identify.
This is a document for which I am not the responsible, I'm not the authorising entity, I can't remember what the exact term is. This was a document that belonged to the Department of Social Services. I am sure the Department of Human Services worked with the Department of Social Services, but I wasn't the Secretary of DSS at that time.
And would the Secretary of DSS be able to explain it, given you've been in that role for a number of years?
I don't know. It's an individual decision. Individual secretaries would determine how they ran their department.
So the limit of your assistance is that you had an understanding that legislative and policy change was required as at 12 February 2015, and by 9 March 2015, someone in the department had changed that position without you noticing and without your intervention.
So on the 12th of February, the briefing that was provided said that DSS had advised DHS that legislation and policy advice change would be required. Somewhere that changed. I don't know where that changed.
But you've previously accepted that the minute reflected your understanding of the state of affairs because you had no reason not to accept the advice.
That's correct.
Yes. And suddenly things slip through to the point where Cabinet is told something which cannot be true.
But I didn't tell them.
But someone from your department had involvement in it.
Someone from the department would have been involved with it, but this is a document from the Department of Social Services.
So you're involved in the minute, you're involved in the costings before the ERC, you're involved in the costings after the ERC, and you say you have no recollection of seeing this document.
I have no recollection of seeing this document because it was part of a much bigger document. The Department of Human Services would have got extracts from, I think, if there's 58 measures, there would have been more than 58 proposals that went through in that budget, and each of the policy departments with responsibility for those programs would have put it in their portfolio budget submission.
I take it on your account you might not have seen any of the documents that went before.
I can't recall. It was 7 years ago.
to start a different topic now. It's your involvement in media matters on a particular occasion or in respect of a particular issue in January 2017. Have Exhibit 1991 brought up, CTH.3001.0033.6554. You can see Mr. Hannon's name at the middle of the page. He's described in the footer as the National Manager for Customer and Media Engagement Branch for the department. Do you recall, not necessarily the 19th of January 2017, but what was described in the media that day as an explosive new Centrelink whistleblower document,
No,
which the Minister had a particular interest and about which you were closely involved?
I don't recall it, but I can read it, but I don't recall it.
Have you seen these documents before now?
I don't think so. There was many documents with media, but I haven't focused on this one.
All right, I might take you to the actual account. Exhibit 1993, CTH.3001.0033.6563. An anonymous account from a person described as a compliance officer with Centrelink was apparently provided to the media and published by a number of outlets on the 19th of January 2017, which gave significant detail about what was going on inside the Department of Human Services in respect of the Online Compliance Intervention Program. Said to be written on a basis of conscience, effectively. The person describes that he can no longer live with what we are doing. Do you recall this critique from the person employed by your department?
I can't recall it directly, but I remember there being matters like this for people who claim to be employed by the department and people who were employed by the department, but sometimes the anonymous, it was not clear whether they were employed by the department or not.
It's clear this person says he's employed.
He says he's employed. He or she
He or she.
says
Do
they're
you think the
employed.
union would actually turn up with a whistleblower who wasn't employed by the department?
I don't know, Commissioner.
Okay. You really seriously thought that the CPSU might try and perpetrate a fraud by producing someone who had no connection with the department to complain about it?
I don't know. When it's an anonymous complaint, I don't know whether the person was, but we acted. My recollection is that we acted on these, but unless I saw their name and their email address, I didn't know whether they were an employee or not. We had at least one occasion where there was someone who was a former employee who said that they were an employee and they hadn't been for 10 years or 5 years or something.
Well, there was a lot of scurrying in the department in response to the publishing of this purported whistleblower account, wasn't there? Or you can't recall?
I've seen that first email. I can't recall whether there were other emails around this matter. There was a lot of media activity at this time.
It was a significant issue for the department in January 2017.
The online compliance initiative? Yes.
The criticisms in the media.
Yes.
Would you accept the description of the online compliance intervention program in the context of the media attention as being in crisis?
Crisis. I don't usually use the word crisis, I don't think.
Say there was a media crisis to respond to.
There was a lot of media issues, and it was I had dedicated most of my time to this matter.
Returning to the document, do you recall settling language in respect of a media statement to dispute the claims made in this document?
I don't recall whether I did, but there may be. It may be that I did. I don't have that in front of me, but you may have it, and you may be able to. You may present it, but it would not have been unusual. We would have looked at what was happening, and by this stage, I was very concerned that people had not had the opportunity, recipients had not had the opportunity to engage with the system, and that there needed to be a number of fixes put in place to ensure that recipients could engage with the system. And that had been my focus, so that recipients did have the opportunity to provide information.
But there was no focus on the question, or the factual question, of how the automation and the application of averaged income would raise incorrect debts, was there?
So there was an acknowledgement that, well, I understood that if averaging was used without the recipient having the opportunity to engage with the system and to provide information, that there was a possibility of inaccurate debts, and my concern was that the debts were inaccurate and procedural fairness had not been provided to the recipient. Subsequently, we got the advice that DSS gave to the Ombudsman about the fact that as long as that we needed to engage with the recipient, and that was my focus, to change the system to ensure that the recipient could be engaged.
Putting to one side this question of legality from the advice, how do you say it is fair to persist with a system where it creates inaccurate debts if people don't engage with it?
Because we tried to get people to engage with it.
So it's their fault?
No.
That they don't engage, and then you're entitled to raise an inaccurate debt?
So we were striving to engage with recipients. And the fact that we put on hold for a period of time while we improved the systems, improved the processes so that we could engage with people. I accept that that was wrong now, but that was the thinking at the time.
Well, wrong in a fairness sense or wrong legally? What are you accepting?
Wrong legally because we were not able to compel people to engage with us, and we were not able to use averaging as a last resort.
Yes, which probably means you couldn't use it as a first resort either.
I think we've been here. We could go.
You couldn't set up a system based on averaging.
So I think we have explored this before, Council. I'm happy to explore it again. But
You're not claiming, though, that you're excused from implementing an unlawful system because you didn't know the law.
okay,
It's not an excuse that washes with most people. You could appreciate that.
so what's the question?
Are you claiming ignorance of the law when
No.
you set up the unlawful system?
So, in 2015, when we briefed Minister Morrison, I was advised, and we put it in the brief, the DSS thought there would be a requirement for legal and policy change. At some point in time, in briefing the Cabinet and getting agreement for the proposal, that changed. I don't know when that changed.
We now know why it changed though, don't we?
No, I don't think we do.
Because there was no change to the way income was calculated or debts were raised.
So you may have evidence of that is the reason. I don't have evidence before me of why it changed. But we do know the advice from DSS did change to the Minister,
How do you know that?
because you just showed me the new policy proposal. And
Where's the advice there?
the new policy proposal, the final page of a new policy proposal has a table which lists whether a number of requirements are in place for this new policy proposal. And one of those requirements is legislation. And on that final page of the NPP that went to Cabinet against legislation, it says no.
That doesn't mean there was advice about it though, does it? It just means they changed the words.
That is advice. That is advice.
To DHS.
No, that's advice to the Cabinet.
So you're saying DSS provided advice to the Cabinet by the letters NO at the back of the policy proposal, which was sufficient to overcome the detail you set out in your minute, even though you knew the substance of the scheme had not changed.
Okay, so I think if you ask Cabinet Ministers, they would think this is advice. They would think that if a department says no to legislation, it means legislation's not required. And that's what they did.
But more to the point, that statement is made on the basis of a scheme that involves no change to the way in which income is assessed or overpayment raised. So it said legislation's not required. That's the proposal. But you knew, well, that wasn't the proposal that you'd put, and you certainly knew at the beginning of 2017 that that is not what was actually happening.
That's right, and in 2017 we were given advice from DSS,
Yes.
and that advice was given to the Ombudsman as well.
Yes. And you had no clue during any part of the implementation of this in 2016 that there was a change to the way income was assessed or overpayments raised? Nothing, you knew nothing of what was actually going on?
So I had a period of leave, in a significant period of leave within 2016, which coincided with the commencement of the program. But I didn't turn my mind to it, and I have searched and I can find no evidence that I had anything to do with it.
You weren't involved in the significant ramping up of the program in September 2016?
Not that I can find any evidence of in my emails.
Okay, and your position is that you just had no clue as to how that program was actually being implemented?
I wouldn't say no clue, Commissioner. I would say that I had left that to be the responsibility of others within the department.
Well, I am interested in whether you did have a clue or not. It's one thing to leave it to others, but did you have any understanding of how the program was being implemented?
So there was a report from the Implementation Committee in October and November about this measure, and those reports dealt more with the achievement of financial targets than they did with the rollout. But those reports were seen by me and sent to the Minister.
Wasn't there a problem with people being cut off age pension in late 2016?
There could have been. Yes, there was. I think there was what was called an escalation brief at some point in November, where there had been an element where people had been cut off. I think the escalation brief advised that the issue had been rectified. I know it looks like there were many escalation briefs in the Department of Human Services. Our IT systems were legacy systems, so it wasn't unusual for there to be an ICT hiccup with recipients, which required service recovery.
A couple of thousand customers who might have had an incorrect calculation of their debt?
Yes.
Didn't attract your attention to understand what had actually happened?
I think it described what had actually happened, and I think that escalation indicated that it had been rectified.
Didn't you need to know what was actually happening with these customers, how they were being assessed?
So I read the escalation brief and it indicated to me that the issue had been resolved. That is the first indication that there was a problem. Even today, I'm not sure whether that problem was related to this or related to some other element. But escalation briefs were very common in the department when we had a service delivery outage or a service delivery failure. So that would not necessarily have, in hindsight, I wish I had dug more into that, but that was the only indication I can find in my records during that period before the media interest of problems with the system. I went back through Senate hearings, and I know that's not admissible here, and I have found nothing else.
All right, back to you and the whistleblower, Mr Gregory.
Thank you, Commissioner. If Exhibit 1855 could be brought up, CTH.3004.0002.5039. I think it's the only page, but if that could just be checked. Is there a further page? Thank you. If we go to the previous page, too far. Back one further.
Provide a hard copy.
We go to the page ending 5040. Thank you. There is the forwarded message, a message 22 December 2016, 12 p.m. from the ESC coordination address. The subject was debt reminder letters are not currently being issued for people who have not repaid their online compliance intervention debt, and the Minister has been advised. You go to page 5041. The issue is set out. It appeared that the system wasn't chasing people to repay debts where they had been identified through the earned income matching online compliance intervention process. You can see that?
Sorry, say again.
You can see the nature of the issue.
Yes.
And the action taken as a result was that letters are being issued to customers that are required to receive the debt reminder letter but haven't yet been issued. Really, this involves the extent of follow-up for people where debts had been identified. And we go right back to the first page at the bottom. Your question was, I'm keen to understand why this issue was not identified as part of the testing. You can see that?
I can see that.
It's true, isn't it, that you were taking a keen interest in what was happening with the rollout of the scheme?
I was by this stage because there was lots. So I had proceeded on leave that day, but I was still engaging. And this was because media, I had become aware about mid-December that there were issues with this system, And so Mr Jackson, who was acting at the time, I'd said to him, I'm keen to understand why we didn't do it as part of testing whenever we rolled out a new ICT element. We did comprehensive testing. There was lots of debate about how much testing we would do, and I'm here asking Mr Jackson why we didn't, asking him to work out why we didn't do the testing. He wasn't responsible for it, but he was acting at the time.
We could go to Exhibit 1242. In November 2016, so about a month earlier, the issue that's identified at the bottom of the page was that in late October, the OCI system resulted in incorrect outcomes for a number of customers. And if we go over, thank you, 75 age pension customers' payments being cancelled. You can see that?
I do, and this was the document I was talking to the Commissioner about a short time ago.
That's right. 600 customers receiving an incorrect payment. Up to 2,700 customers may have an incorrect debt amount raised. There's a problem with the ICT. You can see that?
I can see that. And then, are you referring to the line that says ICT have implemented a fix for this issue and it is working correctly?
Yes.
Yes.
But that didn't remove the concept of averaging, did it?
I don't know that this talks about averaging, this document.
Online compliance intervention involved averaging, didn't it?
It did, but I'm just trying to understand the connection with this document and averaging.
In the context where incorrect debts were identified because of an ICT issue, there was no concern shown about the larger issue of averaging, which might lead to incorrect debts.
So I don't think we had turned our mind to that at that time because I wasn't tracking in November that we had problems with people being able to access the system and the not being provided enough opportunities to engage with the system. And
Campbell, my point to you about this business is really, it's hard to understand when you're hitting problems like this, people being cut off their pension altogether, a couple of thousand getting possibly wrong debts, why you wouldn't be looking at the mechanics of the system to work out how it worked and why it went wrong. Wouldn't you want to know, you're a details person, what was actually going on?
so, Commissioner, if I look at all the escalations that were received during this time, one of the other measures in the budget was to replace our ICT systems. We had legacy ICT systems that, unfortunately, when new measures were rolled out, sometimes had what we called adverse results, which sometimes, because the code had not been documented, and this is 30 years of a Fortran ICT system, unfortunately, we had service recovery requirements like this on a pretty frequent basis. There were examples when we rolled out disaster recovery payment and somewhere in the system that cut off family tax benefit for particular cohorts. So yes, this should have been the first warning that we had a problem, but I note that we were advised that it was an ICT, they'd implemented a fix and it was now working correctly. When I've gone back to look at the documents, I see this is the first indicator that there was an issue with the system.
If you knew you had an unreliable ICT system, isn't that all the more reason to take an interest in what this program was asking of it?
So this system was new. It had been, well, there were new elements of it that had been rolled out. The ICT that paid every payment at that stage was quite volatile, which is why that new measure was in the budget as well, that we were working up at the same time.
Okay, I don't know that you answered my question though, which was, if you know you've got an unreliable ICT system, isn't that all the more reason for you as Secretary of the Department to understand what this very large new program that will involve possibly 800,000 customers will be asking of the ICT system. In other words, what demands are going to be imposed on it?
Yes, and I had the same issue with all the other measures that were due to be rolled out on the 1st of January.
Okay, so it's just a matter of, it's just one among many, so no.
There were many, Commissioner. There were many rollout and so necessarily I would rely on someone who'd sent the escalation telling me it's now working correctly. I believed what was written there.
Thank you.
Very briefly before we conclude, even while you were overseas in your posting between 3 May 2016 and 7 August 2016, you maintained interest in the Robodebt scheme and additional budget measures, didn't you?
Did I?
Exhibit 1757 could be produced. You don't have any recollection of taking an interest in what was happening back here while you were overseas?
I recall talking to one of the deputies about the incoming government briefs.
You go to the bottom of the page, Wednesday 29 June 2016. Subject, saving option. Hello Melissa, I see a saving option on welfare reform has been proposed.
I think that was in the context of the election commitment. That was a new proposal.
Yes,
So
but you're overseas on deployment and you're taking an interest in what's happening in your department with the additional measures which have been announced as part of the recent budget.
it was at 3:14 a.m. So maybe I had a spare moment.
You took your spare moment to find out what was happening, follow up budget measures and see what was happening from Melissa's perspective.
I'm not sure I'd say it was a follow-up. I'd say it was more of a, hello, Melissa. I see a savings option on welfare reform has been proposed. I don't ask her to do anything. It's just, I think it was probably just saying hello to her and just commenting on the fact that this had been proposed. I don't think I asked for any detail or anything like that.
The 4 dots invites a response about the savings option, doesn't it?
So the 4 dots probably said, there's another one.
Why raise it with her if you weren't inviting a response? You're overseas on deployment. It's obviously important to you.
So does it mean that I'm not allowed to talk to anyone?
Never said that. What I'm suggesting is a continued interest despite the fact that you have other pressing things
I think it was
overseas
a continued engagement with Melissa.
about budget matters for the Robodebt scheme.
We're very boring public servants. Sometimes we talk about these things.
And not anything else according to your text.
I probably was being pretty careful what I wrote because it was not on a secure system.
Wouldn't have been secure to say, how are you? Are you well?
Are there other emails that I might have said that to? I don't remember what I wrote to people.
It's direct, it's to the point, and it's an interest in the Robodebt scheme budget measures which had just been announced.
Been proposed.
Proposed.
So are you saying it's the ones that had been agreed? This was a new, I think there was...
I'm saying you had a continued interest in the budget measures.
Yeah, I don't think I was asking them what they were doing with their code. I think it was just a passing comment.
Convenient time, Mr. Greer.
Thank you.
Ms Campbell, I think there's a proposal for you to come back on Friday, but I'm not sure. What's the situation?
Yes, Friday morning, I think we might be able to start at 9:30.
Tomorrow morning? Oh, sorry.
Friday morning.
At 9:30 start. All right.
Yes.
We'll adjourn till 10 tomorrow. Thank you. I'm sorry, Ms Campbell, that was meant to indicate that I think you are needed again on Friday at 9:30 seems to be the idea.
Thank you, Commissioner.
All right. Tomorrow, 10. Thank you.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.